Wait, please, your Lordship. Lordship, in connection item number 1, Lordship, we have to file additional affidavit, Lordship. We have applied for some voter list, Lordship. So,
Sorry.
Lordship, in item number 1, we have to file some additional affidavit, Lordship.
Yes. Let the item be called. We'll get into it. Yes. Any more mention? Now you say whatever you say.
Lordship, we have applied for a voter list for Lordship.
What voter list?
1985 Lordship in Solapura and Sotopolia Lordship, 2 villages Lordship. So we need some time to get.
Yes, got it. Where is the certificate? Which page?
Case number 101 Lordship.
101. No, this is a register.
Yes, sir.
At the best, that a certificate was issued.
Yes,
We have no
Ex-
difficulty in accepting the certificate was issued.
yes, that
We want to know on what basis that certificate
Yes.
was issued.
Yes.
It was casually just because somebody came to me,
Yes.
asked for a certificate I issued, or there is some public material,
Yes.
public record,
Hmm.
which warranted the issuance of the certificate. Where is that record?
Except this, nothing is available.
Then this is one, it is the individual discretion of one circle officer.
Yes, yes,
If I like, I'll issue it. If I
Yes.
don't like, I'll not issue it.
yes, your Lord.
What value will these certificates have?
Yes,
What is a certificate?
yes. Other things are not.
No, no. What is a certificate under the law?
Certificate is a recognition, your Lord.
No, no. What is a certificate?
Proof document, your Lordship.
What proof? So if you admit it is a proof document, you are agreeing with the petitioner.
No, your Lordship, that is only the date is there, your Lordship. That on that date,
Certificate is a document which shows the existence of a fact.
yes, yeah.
Okay.
Yes, your Lord.
And this existence of a fact can be shown either by the personal knowledge of the person issuing the certificate
Yes, your Lord.
or on the basis of some public record.
Yes, your Lord.
Understandably, this is a document issued on the, not on the personal knowledge, but on the public record.
Yes,
So you want the public record.
yes.
And if the public record is not there, we have to question this certificate officer, why he issued this certificate. Is he still in service? 2007 circle officer, who is he? Or if the circle officer had a personal knowledge that at that relevant point of time, I used to visit the house of Shah Jahan every day.
Yes.
One day when I went to visit his house, I found that his house is not there anymore. It is
Yes.
eroded. So I issued the certificate.
Yes.
We accept it.
Simply date is there, issued so and so, like.
Lordship,
We'll hear you. We are on a different issue totally. So what do we do with it? Even the copy of the same could not be traced.
Yes.
So they don't even maintain a copy. Eroded certificate. बाकी तो eroded certificate मान लो। Information colportals, control check. Notes of wages bill of Hasna, order of release of certificate if you register campaign pages 1 to 107. बाकी तो सब delegable purpose. mention করা হলো delegable. No, occasion manual is delegable. Itu Pak. Itu boleh saja gitu. Yes, what you are trying to say?
Lordship, in the meantime, we have got one voter list of 1971, Lordship. And on last Saturday, one notice has been received.
One what has been received?
Notice, Lordship, which was
Notice-
forwarded by the Warden of Police SP Border to surrender before the SP Border on 16/9.
Go and surrender.
Lordship, so
No, go and surrender.
we need some time to file
First
additional.
you prove
addition-
your case, you will get the interim order. But until you prove your case,
Lordship, that's why we need.
Was this certificate also exhibited before the tribunal?
Lordship, yes.
This particular
Lordship.
certificate, what page 101,
Lordship,
it's exhibited.
Lordship. It's the money.
Hmm.
Sorry, Your Honor, GP certificate was executed.
Order of club document of आपको अपना मिला रॉन्ग आइडिया যদি রঙা চালিছে গোটেই তাতকৈ টানি দিয়া হয় এইখিনিৰ পৰা হেৰি দিব পাৰি certified that issued report contains pages from 1 to 117. And ask pages 107. Pursuant to our order of 2/3/2023, the circle officer, South Salmara Revenue Circle, had produced the issue register from pages 1 to 117, wherein at page 25, the recent entry wherein there is an entry number 3648 dated 5/7/2007 that an eroded certificate was issued in favor of Shahjahan Ali. The forwarding note of the in charge circle officer, South Salmara Revenue Circle, dated 18/8/2023, provides that although the eroded certificate was issued from the office of the circle officer, but a copy of the certificate could not be traced out in the office record. By the order of 2/8/2023, we required the circle officer to produce the public records based upon which the certificate was issued to substantiate that there was an erosion. The circle officer to produce the public records based upon which the certificate was issued. Public record or any other knowledge based upon which the certificate was issued. Based on so and so. And if you want to bring something more, you file affidavit. We'll see to it.
Complaints, Your Lordship.
Outline.
Pay the cost. No, you take it back. Your statement is good enough. You don't have to produce documentary proof. Documentary proof you produce regarding your merit of your case.
They have informed me that the land document is not, they have obtained, but they have applied, but.
Is the microphone off? Please check up. On. Maybe you to increase the volume.
Lordship, the petitioner informed that they have applied the land document in which the three paternal uncle and along with the father of the petitioner name appeared in the same land document. But yet to be obtained that land document and voter list of 1970 along with petitioner fathers and two paternal uncles.
Now, what is your case? The adjournment to produce further material to a petitioner is the daughter of Iman Ali, whose name appears in the voters 1965. What is the report of the SP?
It was reflected
Lordship,
Or that we already considered.
only for purpose of NRC. Lordship.
So now you are taking time from 2023. How
One,
many months have gone by?
the last chance,
More than 6 months.
that is.
And when will the last come to an end? The last word has a meaning
Lordship,
that no further.
and that is correct. Lordship.
So, no, it is not correct. It is correct, but nothing else.
Lordship, every time I have informed the petitioner, but.
So we understand you have no material. We close your petition. What is to do? Finish your petition.
One more.
It is noticed that the petitioner is repeatedly seeking adjournment from 22/2023 to produce any further material which may show that the petitioner Jarina Khatun is the daughter of Iman Ali, son of Basir, whose name appears in the voters list of 1965 of village Uttar Adiabari. Today again, when the matter is called, Mr.
A. Hussain.
A. Hussain and counter petitioner seeks for an adjournment to produce further material. No further time shall be granted. List on so and so to produce any material if available with the petitioner. List next to. If you have, bring it. Otherwise, we close.
Okay,
We
no,
can't go on,
I have no
continue.
problem. Next.
Sorry.
If they no.
See, Mr. Hussain, first of all, we are not required to give you time. First, take note of that, because whatever you have to produce, you should produce before the tribunal.
Yes.
We are giving you the extra mile that here also you prove your case if you have something. But why should you repeatedly go and adjourning your matter? If you have material, you should bring it the very next day. That means you don't have. Now you are trying to create material. Definitely. See, if you have to pay 10 rupees to the court master, if you have it in your pocket, you can pay it right now. If you don't have to pay in your pocket, you have to borrow it from somebody or get it somewhere. So you'll keep on taking time. Same is with your material. You don't have it. Otherwise, there's no reason to repeatedly seek time for last 6 months. Next week, fixed date. Either you bring it or we close it.
Master.
The petitioner is duly informed that if no further material can be produced, the matter will be taken up on the basis of the existing material on record. Petitioner to take note. I inform her. Yes, Mr. Chakma.
Yeah, please, sir, let's see. Let's see, we're supposed to find our additional affidavit.
Intends to file an affidavit in evidence of a person who is claimed to be the brother of the father, and who is also migrated along with the petitioner. Assam Refugee Federation, what did you say?
Yes, Lordship. Written instruction is not available, Lordship, but telephonically I have talked to them, Lordship.
Hmm.
They said then they did not see like that certificate, Lordship. And Lordship,
Mr. Chakma.
election commission can verify.
No, it's a private entity. What record will the election commission keep for that?
This
Mr.
certificate
Chakma.
regarding genuinity of that certificate.
When
Lordship.
these refugees were coming, some more enlightened person deemed it appropriate to make it a political mandate out of it. Possibly he wanted to become a leader. So he formed a private association and started issuing a certificate, thinking that as if
Yes.
everybody will accept him to be an authority under the law. So this is the fate you are making. No private authority can issue certificates.
Regarding
And even the police doesn't know about the existence of this entity, Assam Refugee Federation.
Yes, that's it. But there are many.
So how can we give any evidentiary value of a document issued by an organization which itself is existence is in doubtful? Not doubtful, no one knows that whether it existed or not. One private man in his residence must have started issuing certificates. You also went to him, got it.
What's it, the petitioner fathers were illiterate.
Hmm.
They don't know about,
Sorry,
and the fathers of the petitioner, they were illiterate. At that time.
father of the
They don't
petitioner.
know what's it.
Oh, you want to go for the first one? Brother of the petitioner, father.
Yes,
Who is the brother of the father?
what's it?
Because on 26/7,
Yes, what's it, we need.
you submitted that you want to bring in evidence, affidavit in evidence of a person who you understand to be the brother of the father of the petitioner.
Yes, Lord.
Have you brought it?
No, that's which we have tried to communicate with the petitioner. Lord. Today we will communicate in written way. Lord. So we need some more time. It's better.
It's a matter of which year?
Yes, Lordship, 2018.
How much more time will it give you?
1 week.
1 week, Lordship.
1 week more to be given. Yeah, about this, no, same order. But mind you, we can't keep on giving it time.
Lordship. Deeply.
Fixed area that we go. Does the brother exist? Or what is the difficulty? You are unable to contact your petitioner.
Yes, Lordship. My senior tried to contact with the petitioner. So we will.
Mr. Sharma, if the client is not contacting the lawyer, ask the SP to take to custody and bring her here.
We will.
Let her be produced before the court.
Lordship, we don't have the direct communication with the petitioner because she don't have the phone and all. So we have tried to communicate with the other. Now we are will write a notice to the petitioner, so she will appear, Lordship.
No, if you're having difficulty petitioner to contact the petitioner,
Yes, Lordship.
we can have the petitioner before you in the court itself. We'll ask the SP to bring her here.
We'll send a notice once if she is not compliant to come. So then the SP border can take steps. No need to hence. much.
So otherwise, what they can do, they are trying their best, the person is not responding. So
Yes.
the person,
Just like yesterday.
that's one way out. of it.
Yes.
Yes, next item.
Much.
Question my seniors in Legon, code number 1, kindly adjourn the matter.
Typing a day.
Wait, please, your lordship.
Oh, bro.
Even know what happened.
Wait, please, your lordship.
Lordship, in this matter, I need some time.
Adjourn on the prayer of MSB Decca Land of Education Department for doing the needful as indicated in the order of 26/7/2023.
I leave.
Yes.
Your lordship, we have filed an affidavit in reply, stating all the events which was taken place during the post
It's for
investigation.
adjournment to find an affidavit, bring on record as to on which date, what time. Where is the affidavit? Any idea which page number?
It's page number 29.
29. It's not affidavit in reply, actually.
They have filed an affidavit in opposition.
Okay,
and
they filed an affidavit. So you are giving a reply to that.
reply to that.
What is their stand in the affidavit?
Their stand is, your
Which page?
it's page 14.
1/4.
Is there?
Mr. Nath, you are appearing.
Yes.
No, where is the precise time? Regarding your presence in the police station, where is that stand of their stand?
It is in paragraph number 4,
4. Statement made in 3 stated that the other was based on the
last
FIR
paragraph,
5. Page
Yes.
number
page number 33.
33. That is your reply.
Yes.
No. Acha, they didn't say anything about that incident, what happened in police station.
Nothing.
No, paragraph 5.
So you are now bringing that on record.
Yes,
Okay.
yes. At the same time,
And just a minute, I was taken to the Alabari police station, everyone wanted to mean, I was kept there for a half hour for half an hour. Approximately. You are not supposed to use abbreviations. Approximately, write the whole word. Why approx then full stop and all?
because your
Not
lordship,
because in a pleading you are not supposed to write. There is no because, there is no reason. Mr. Nath, what is the meaning of this Papa vehicle? We notice it moves around in the road at times.
These are patrolling vehicles. sir.
No, what does it mean,
No,
PAPA?
Papa, exactly the.
In fact, this question I've asked many people, no one knows the answer. But many vehicles contain that initials.
Papa knows.
And it is also known by the public to be Papa vehicle.
Lordship, I'll just.
Any idea? Papa vehicle one. No, no, purpose to remove, purpose to remove.
Okay, jump down. Jump. Come back with left. Petroleum vehicles will not cover.
Yes, Mr. Nath. Other aspects, we are not much concerned.
Gotcha.
Police case registered, you will investigate, you do whatever you do.
Yes,
You bring it to its logical end. But what about the conduct of the police while dealing with the matter? Is it acceptable? What is written in page 33,
gotcha.
just please read it. Is it acceptable in law? Considering the status of the person concerned. We have noticed a number of infirmities, not just one.
Logic,
No, no.
from
Other aspects will
Gotcha.
deal separately,
logic.
and possibly we may or may not enter also, depending on how the matter progresses.
Look, Malak.
But this aspect, what you do, how you investigate, where to investigate, it's always the prerogative of the investigation. Red court should normally very rarely interfere, or in fact, to a great extent, not interfere at all.
Logic.
But conduct of the police is always within the jurisdiction of the court.
Malak, in the affidavit, the minute details of the incident has been given.
Hmm.
Let me have some instruction on this.
Definitely.
Logic.
I think first time you are going through it today.
Yes, yes.
When should you fix it?
Logic, give me 2 days time.
And the
Please, tomorrow
petitioner has given a detailed description of what transpired in the police station on. What was the date? On the night of 16/5/2023. That is 11:30 PM to 4:30 AM of 17/5/2023. Mr. D. Nath from Senegal Advocates takes notice of the said contention of the petitioner and seeks to respond to, seeks some time to respond to the
To
same.
take the instruction.
Respond
Logic.
next week, fixed date.
Logic. Logic.
28.
Any date you want,
Malak.
28.
28.
28. But your lordship, the main question is in the affidavit in opposition, what they have stated in paragraph number.
See, madam, we are distinguishing two aspects. One aspect in what manner the investigation is going on, what manner it should go on. Other is the conduct of the police during
Yes.
the investigation with the person concerned. Okay, so time being, we are dealing with the second aspect.
Well-
First one, we'll deal it separately. Because there the scope of the repetition is very limited. But treatment that was meted, that is totally different aspect.
Logic.
And Mr. Nath, please take note of one aspect.
Malak.
Was taken to the Jalukbari police station. So when a person is taken to a police station, there must be a GD entry number 1 at least.
There has to be.
Ha. Then there must be a FIR,
Yes.
Ejahar,
Yes,
Where is the Ejahar?
case diary I have received.
Can you take a look at the Ejahar?
This is the GD entry, Malad.
No, where is the Ejahar?
First page, Malad, then it is first page.
This page number,
Lord.
this itself is the Ejahar.
Now, in that bunch, Malad, the first.
First page.
Lord. Lord.
Where is the hospital record?
One report is there, Malad.
No report, any hospital record. is
Hospital
there?
record as such.
What kind of treatment was the person given? You were given, I mean.
Nothing, just only 2 tablets and one simply, they gave me some ointment.
No, tablet and ointment is okay. Was it recorded anywhere? Was any prescription given or anything?
That I have annexed with my writ petition.
Where is it?
Date and time of entry is 1 AM. They have written in the medical case report.
Huh.
It is annexure A in the affidavit filed by us, Malad, page
Hmm.
22.
At page 13 of my writ petition.
Just. Page 13. Page 13. Where is page 13?
One
Writ petition,
one.
mean writ petition.
I understand mainly, but. Page
That is the prescription only.
Both is shared.
Time is very much. Time is very 6 minutes.
Seven, 5.7. 5.7. যেরকম খবর আছে বিফোর এখানে গ্যাস খবর আছে ইটিআর দিছে বুক পাইছে কারণ ইটিআর দিছে ইন্ডিভিজুয়াল দিছে
Does the police normally take the informant along with them when they go for investigation?
The informant is here victim, that is why she was.
I understand, victim or otherwise, even the victim. Does the police manual require that when you go for investigation, you take the informant of the victim along with you all everywhere?
No, in each and every case may not be required,
But in which cases it is required?
if identification is required.
Ident-
Identification
So-
of victim, then.
Okay, where is the provision? Let us see the police manual.
No, I'm not ready right now, I'll,
Because reading of the GD entry goes to show,
yes.
মই এতিয়া মোৰ সংগীয় ষ্টাফ সহ গছৰীয়াক লগত লৈ চকীৰ পৰা ঘটনাস্থলীত আহি উপস্থিত হৈছো। Why?
I have. to-
Because we have read a number of CDs, number of GD entries, especially in those criminal appeals also, those 302 cases also. Nowhere it is noticed that the informant is taken in a vehicle by the investigating police and taken around everywhere.
Now, here I have seen.
So what was the special requirement to do so in this case?
I'll
Let's ask the police.
Yes, I'll ask. And in the case that I have also seen that.
See, up to this extent, it is okay. When the informant or victim went to the police, you recorded the statement under 161. That is very good.
Logic.
But after that, after recording the statement, এতিয়াও মই মোৰ সংগীয় ষ্টাফ সহ গছৰীয়াক লগত লৈ চকীৰ পৰা ঘটনাস্থলী অভিমুখে ৰাওনা হৈছো। Next, after 10 minutes, এতিয়াও মই মোৰ সংগীয় ষ্টাফ গছৰীয়াক লগত লৈ চকীৰ পৰা ঘটনাস্থলীত উপস্থিত হলো। গছৰীয়াই দেখুৱাই দিয়া মতে ঘটনাস্থলী পৰিদৰ্শন কৰি। Is it necessary?
Under what
Especially
circumstances,
a
sometimes maybe.
Sometimes. So let us see when you do it.
Yes.
Circumstances which justifies.
Yes. I'll have to find out. I'll ask them.
And that too in the middle of the night.
Time is middle of the night. That's correct.
See, you want to
Logic.
take up this aspect a little more seriously
Yes.
than the other one.
Logic.
Other things are okay. You're investigating, you do whatever
Logic.
you want to do.
Your lordship, there is a huge problem. The problem is even though for a medical requirement, that is what in the last date also I say, even for the medical requirement.
And interestingly, the medical document, Lordship had found out it's time 1 a.m.
1 AM. Yes,
But 1 a.m. your GD entry 12:50 মই এতিয়া মংপঞ্জি থানাতে মুকলি কৰিলো means
yes.
open the GD entry
FIR received at 12:30.
12:30 very well
Yeah.
you took 20 minutes 12:55 you were taking the statement of the informant
Lordship,
statement goes on
Lordship.
1:10 মই এতিয়া মোৰ সংগী ষ্টাফৰ লগত লৈ চকীৰ পৰা গলো so how the medical report says 1 p.m. the person was in the hospital your GD entry doesn't say so.
But
Yes, medical concern 1 p.m. Full page of it come to page 22.
yes, yes. I have seen, right? 17.
75 1 a.
1 AM, yes. Date and time of entry.
So doctors normally don't write all irrelevant things.
Yes.
It is understood. And the doctor is conscious because initially he wrote 16:05. He realized that time is gone now. It is not 65. Immediately 16:05 was struck off and he made it 17:05. So the doctor was conscious about the time.
But Lordship is indicating from
Page 13.
prescription. Lordship.
See, initially 16:05 is 16:0 is written
Hmm.
for the 05.
Hmm.
Realized it is that in the meantime it's
Meantime.
past midnight.
Yes, sir.
Immediately made it 17.
Lordship.
So when the doctor wrote the report 1 a.m., it is understood the doctor was aware of the time. So if the doctor was aware of the time is 1 a.m., GD entry does not say something different. GD entry says they were taking 161 statement at that relevant point of time.
Yes.
But
Whatever is available in the record, my lord, we'll have to go by that.
You have
only.
to take
And
note. And
minor-
then
Lordship.
again,
This
another disturbing.
minor scrutiny by this petitioner at this stage may hamper the investigation. Lordship,
Scrutiny regarding the conduct, Mr. Nath, it will be done.
Lordship.
Police cannot prevent their otherwise illegal act in doing an investigation just because in the name of investigation. Your investigation part, we are not touching for the time.
My lord.
But your conduct will not, because it is an investigation, that doesn't mean police can do anything they feel like.
Under what circumstances they have written.
So now we are only confined to page 33,
Yes,
not for the other purpose. And other one to where this SI took me allowing them to the residence of the accused, where the main culprit flew away, co-accused were caught, were brought in the same Papa vehicle. So the victim and the accused are again dumped into the same vehicle and brought together. This is also not warranted by law. Any victim who approaches the police, that victim is not supposed to be huddled with the accused again thereafter, at least by the police. Then, and I was kept in the police station and I asked him to submit my written complaint in the morning. Then I was forced to write the complaint by the SI in the desktop system of the Jalugad police. Thereafter, I wrote the complaint and took a printout, giving me a copy. So this is after 2. And your GD says the FIR was received at 12:30.
Your lordship, CCTV footage may be brought on record.
Maybe
For the
sometime-
entire police
sometime
station.
they'll be. Let's see how they respond.
Lordship.
If I
And
respond.
I have one more aspect to lordship, then I will end.
No, next day. Today it's over. Yes, next day. We have taken up your case regarding the what is.
No, no.
Oh, it will hit them for a look. Take back the.
This case, Lordship.
Yes. Yes. The order of the name of the school is read as Polahaguri and number not. Order will be Sorry. You don't need. Yes, please.
On last occasion, as for Lanet, the council education was directed to take instruction. But due to some personal inconvenience.
Who was directed to take instruction?
Regarding registration of a police case at Zagreb police station.
Acha, that information.
In that information, Lordship, but the escort is not available today.
So who is not available?
Escort. She was directed to take it.
Please don't. For the information regarding the for the information and particulars of the police case that may have been registered.
May I please, Lordship. Lordship, item number 4 and 8, Lordship, my senior is report number 1, Lordship. I'll for that maybe. Much.
May appeal, Lordship. Father name is Joinal Abdin, my lord. Page 19, my lord. Land Jamabundi of 1958, 65, my lord. Serial number 2, my lord. Joinal Abdin, Pita Monsoban, Joiner.
Who is he? Father?
My lord.
Father.
Joinal Abdin, my
This was Tita Pani Moser,
lord. Kandulia village.
Kandulia Gaon. 1958. How can it be 58-56? So 65. 65. Yes. So no, but,
Next, my lord, voter list of 1970, page 26.
Father.
Yes.
So this is the entry of which year?
Entry started, my lord, page 22, my lord.
No, this page 19, Zainal Abed.
Fine, yes.
By which order of the circle officer his name was entered?
Yes, that part, my lord.
That will be relevant because
Yes.
that will contain the date.
Yes, that part, my lord, hearings, my lord, start from page 22, my lord. I have not seen
Mr.
the,
Ahmed. Jamabandi is almost like a continuous document.
yes,
It's a document of 1955 doesn't mean every entry is of 1955.
yes. it is.
Subsequent names may be entered
Ah.
at a later point of time.
Yes,
So the relevance is by which order of the circle officer this name was entered.
yes.
That will give you the date on which it was entered.
Yes, my lord, but
Where is the order of the circle officer?
that part I have not seen in
You have to
this.
find out. Otherwise, there's no meaning.
Yes.
Suppose in a Jamabandi may be of 1950s. I may enter my name today also.
Mhm.
my name will also be found in the same Jamabandi.
Yes.
That doesn't mean I existed in 1955.
And voter list, my lord, 19.
So we ignored this one. Page 19.
Subsequently, I'm coming now.
No, you cannot come subsequently. First you come, finish your.
Voter list
by issue
19,
and then
voter list 1970, my lord,
Page
page
number.
26,
60,
page 26.
26.
Serial number 47, Joinal Abdin. Father name is Moncho
Okay,
Bhai.
father, very well. So now, who is the petitioner?
Petitioner number Sabia.
Sabia Khatun.
Yes.
Which method will Sabia Khatun is the
Yes.
daughter of the
Page 42, my lord. Page 42, right part, bottom, my lord.
অপৰাবিষয়া মহোদয়ৰ 2011 চনৰ তাৰিখৰ হুকুম মতে এই পত্তাৰ দাগত সূত্ৰে
পুত্র থেকে
উত্তৰাধিকাৰী সূত্ৰে 2 নম্বৰ পাত্তাদাৰৰ স্থলত 2 নম্বৰ পাত্তাদাৰ is that man
জয়নাল আব্দিন,
জয়নাল
page
আবেদিন।
40।
স্থলত সোহৰাব আলী, সোবাহান আলী আৰু who is the petitioner? Sobia,
Sabia,
Sabia.
yes,
Okay, where is
serial number 6,
Where is Sabia? Serial number 6.
page 42, right. Jaida Sabia, Pita Joinal Abdin.
Yes, what do you say? Lordship is pointing out, Jainal Abedin's name was entered in the Jamabandi by the page 24 order, 5/2/2003. So the Jamabandi is relevant for Jainal Abedin on and after 5/2/2003. Not prior to it.
Page 42, my lord, top, my lord.
Page 24, Mr.
Page 24, my lord.
Hmm.
Here
First
is,
read it.
yes. Chakravikar 6/2003,
3,
হুকুম মতে
Kumate.
উত্তরাধিকারী সূত্রে
পুত্রে
এক নং পাট্টাদার স্থলত 217
এক
আৰু
নম্বর পাত্তাদার is
1 নং পাট্টাদার মিন্স হানজু শেখ,
Hanju Sheikh.
Page 19. স্থলত 337 দাগে সোরহাব আলী, সুবাহান আলী, শহীদুল ইসলাম, পিতা জয়নাল আব্দিন, সকিনা খাতুন, স্বামী জয়নাল আব্দিনের নামত নামজারি করা। Not named in the Jainal Abedin.
of Jainal Abedin.
Yes,
They inherited the land of Hanju.
yes.
When was the name of Jainal Abedin entered?
Yes, my lord, I have not seen in this Jamabandi, my lord. In the
That will
Jamabandi,
be
I have not
more
seen.
helpful to you.
Yes, it
If
is.
it was entered in
Yes,
1960s, that means Jainal Abedin existed in
Yes.
1960.
it is important,
Then
my
you
lord.
can make out your case.
Yes.
The petitioner may produce the relevant order of the circle officer by which the name of Jainal Abedin was entered in the Jamabandi, available at page 19 of the writ petition. 19 of the writ petition.
My lord, that part may be easy by the government, my lord.
Make a certified copy if they don't give.
Yes, I will try my, I will
Give
inform
us
my
the
lord.
certificate copy, we'll ask them to give it to you.
And I am furnishing copy, my lord, government.
If we can produce that order, You don't have to go to voters list. Only by the land document you can prove your case. Page 19, plus the order of the circle officer.
Yeah.
The red with page 24 and 42, you can make out your case.
Yes.
My lord, in this case, lordship passed directed us orally that the petitioner should.
Oh, they're easy. That
My lord,
person.
he has come, my lord. Yesterday, in fact, he has come.
Hey, does he have any family?
His son is. They are the son, my lord. Few days ago, he suffered a brain stroke, my lord. Thereafter, is unable to move freely without support.
How we are going to prove or disprove his case? Because he apparently has no material. Because he does not remember who he is, whose child he is, from where he came. He was initially picked up by
Moinuddin Munshi,
Moinuddin.
Munshi, then handed over to Dhoniram Saikia.
Then Moinuddin Munshi handed him over to Dhoniram Saikia. Then after some time, Dhoniram Saikia handed him over to Tajuddin. Tamizuddin. So accordingly, he grew up. Now this is the age he has reached. But what about his children? This person, we can protect him. But what about the rights of the children? His children? No, you don't have to bring him. What about the rights of his children now?
My lord,
This man, suppose because of his condition and circumstance, we protect him. What about his children?
my lord, what he is given, my lord, that may also be inherited by the sons, daughters, my lord.
No, he will only protect him to a limited
Yes, son
extent.
and daughters are also.
Understand? We can protect him to a limited extent, not to the complete extent,
My,
because we have no material.
mother আছে না? The Lord, so we can, need to be protection by limited protection. Son, daughters also should get. It will any solution again. Next, record of the same. Have notice to Pakistan. Notice to. Notice to Pakistan. And someone even separate. Separate ways. You go to wedding notice. That will be this one. I took video class. I will say,
Business center. Normally, in any other case, it's a burden of the state to prove whether he was citizen or not. But in these cases, section 9 says the burden is on the proceeding. Mr. Siddharth, please say something. In these nature of cases, the burden is on the proceeding. Section 9, burden is shifted. अपनी बहुत बोलो keep him standing there. Right. What Sogi Jota se and don't bring me again. We did not know about this condition. We wanted to actually interact with him. But now it appears you cannot interact. No purpose will be served. And ask that other one to not to make all those dramas here. Ask him to go out. We are concerned with this man, not with those others. These are cases to prove something or not this all this behavior here. This person we can protect him. Okay.
My lord.
As he cannot prove his case, because his case is that as a child he was abandoned in the Dharmapur railway station. One Moinuddin picked him up, brought him up for some period of time. Moinuddin handed over him to Dhoniram Saikia. Sorry. Dhoniram Saikia. Dhoniram Saikia looked after him for some time. Then at a later stage, handed over to Tamizuddin. So, whatever it is. And he took care of this person and ultimately he has reached this stage. So, he cannot discharge the burden because he himself doesn't know. As a child, he is abandoned. He doesn't remember anything. Must be at quite a small age. But what about his children?
My lord,
Some moment.
my lord, the inquiry report says that the proceeding was initiated directly, my lord, only against the Abul Hussain, not against the son, daughters or wife.
Sikdar, you are more on technicality. We are on the substantial part.
My lord.
Okay, today we'll discharge them. They'll give them one more reference notice. They'll come again.
Yes,
But
my lord.
what will they prove? Technically, it is very easy to say
Right.
that this time it will not happen. They'll give him one more notice, one more reference will come. But what will he prove? Children can prove that they are the son of this person.
Yes, my lord. Yes, my lord.
This person, it cannot be proved who he is. If he cannot prove who the father is, children also cannot prove anything. This is where we are concerned.
Right.
That's why I asked the question whether he is having family or not. Had he not having a family, we'd have given him the full protection.
Wife has
Because
died.
on the principle of impossibility to prove.
Yes, my lord.
But children,
My lord,
that will be a bigger issue.
yes, my lord. My lord, children, my lord, they born here, my lord, and the father's identity, my lord.
Born is. Yes, Mr. Agitechari, born, again the word born has come.
And father's position will be automatically.
Nothing is automatic. This is a difficult. Only those cars are automatic now without any gear. Law, there is nothing is automatic. Everything is, we have to go by the principles. Or you can, as a special case, you possibly will have to give them
That is what I was telling him.
As a special case, without precedent for anybody else.
That is what. Because in other case, he could have applied for
No,
registration. but
Other one
here-
is different. So therefore, we'll hear you in detail on that.
Yes.
That's a totally different aspect. In this case,
This is a peculiar case. It is
I think we have to give the benefit to the children also.
that has to.
Children are. It's a God wish that they are born with this man as a father.
There is no other way.
Give them the citizenship without any precedence and because of the peculiar circumstance. That's the only way out.
Will not be covered under any rules or.
Under any rules, nothing as a special case, it's a on the discretion of the government of India, we are giving with the citizenship.
That has to.
নহলে কি কৰিব? বেলেগ তো ৰাস্তা নহয়। ইহঁতে তো কৰিব কেনেকৈ কৰে? He was found in abandoned condition in which year?
My lord, in the. They cannot say exact the.
The difficulty is all the 3%. Moinuddin, Dhoniram and Tamizuddin, all three are those.
Only Dhoniram Soikia's son, Manik Soikia is.
But Dhoniram Sekha's son also doesn't know anything, what his father had done.
Definitely he is older.
Uh,
He is older. Subject to lordship says.
So just look into this aspect, you also take a little more interest, a bit of interest in this. Whether you can invoke the principle of impossibility to prove and draw a presumption, not presumption also, as a special case.
That is what I was coming to. Subject to what lordship says.
We are not passing the order today, definitely.
Something was coming in my mind.
Sure.
If I can take it up as a special case with the ministry. lordship.
That's what we're thinking.
Let's see what. is-
Special case without anything on the discretion of the government of India.
Yes. Let me get their response.
We are granting them. And not to be as a precedent for anything else.
Yes. The lordship will give a reflection in that.
Third, we also requested the presence of Mr. Akhil Soli and give for the Union of India. The petitioner number 1 before the court, namely Muhammad Abul Hussain, is a person who is presently aged about, how much will be his age, Mr. Singh?
72 years.
Aged about 72 years. And the other petitioners are his sons,
Wife has.
are
expired in
his
the-
wife and son. Wife has to prove separately. Wife must be the daughter of somebody else. We are not on the wife. Are the wives and sons of Muhammad Abul Hussain. Where is the evidence regarding Moinuddin, Tajuddin and Dhoniram?
My lord, so this is an excel. My lord, everything will have that. Evidence will have put. We cannot say him. Annex government. My lord, evidence are not annexed, my lord. But we
But
have
you have
extra
to
copy,
keep-
my lord. Annex government.
Who is Khalilur Rahman?
Khalilur Rahman is the son of Moinuddin. Mainuddin, who has found this man first time?
PW1 Khalilur Rahman, son of late Moinuddin of which village? Nothing better. Khalil Rahman is of which village? Why don't you write the information in a complete manner?
Original.
When evidence is taken, why the complete information cannot be recorded? It's a type copy. Does the origin contain it? Please take copy.
Original to good. Original to good. Make it yes. We should just.
In his deposition before the tribunal as PW1, stated that he is a teacher. Who is a teacher, in his deposition before the tribunal as PW1 stated that Abdul Hussain was brought by his father when he was a child in an abandoned condition. After 3-4 years, Abdul Hussain was then brought up by the Gaubura of the village, Dhoniram Saikia. And thereafter, after staying in the house of Dhoniram Saikia for a period of time, he was thereafter brought up in the house of Tamizuddin. It is an admitted position that Moinuddin, Dhariram Saikia and Tamizuddin are no more. In the circumstance, a question would arise as to who is this petitioner, and as he had been referred before the tribunal, a further question for determination would be as to whether he is a foreigner under the Foreigners Act 1946. The materials and record, as indicated above, indicates that the petitioner Prosidi Abdul Hussain was found in an abandoned condition by Moinuddin, and Moinuddin took him to his house and brought him up for a particular period of time. Thereafter, his custody was with Dhoniram Saikia the Gambura, who again brought him up for a particular period of time. And thereafter, it was Tamizuddin who had brought him up. The petitioner Abdul Hussain has no knowledge or information as to who he is or from where he came from. On the question of discharging the burden under Section 9, both possibilities are open, that he may have been a son of any parents who are Indian citizens but was abandoned. It is also equally possible that he is an illegal migrant himself, or he is the son of some illegal migrant who was abandoned, resulting in Moinuddin finding him in the abandoned condition at Dharampur railway station as stated. As Abdul Hussain has no knowledge about his origin, it will be an impossibility under the law to now expect him to prove whether he is a foreigner or not by discharging burden as to who he is or from where he came from. As the three persons, Moinuddin, Dhaniram Saikia, and Tamizuddin are also no more, there cannot remain any situation where an inquiry may be made from the aforesaid three persons regarding the origin of Abdul Hussain. In this circumstance, we have to understand that in the present case, in the circumstance, a situation has arisen that it is a situation of impossibility to prove under the law as to who Abdul Hussain is. Taking note of the aforesaid circumstance, we request the authorities in the Union of India to express their views as to what status can be given to the petitioner. Keeping in view strictly confining to the facts and circumstances of the present case, without it being a general proposition in any manner. A copy of the order we provided to the for further response. You don't bring him, let his sons take care of him. No, it's also noted. In the circumstance, we required the petitioner Abdul Hussain to remain personally present before the court to court for an interaction as to whether anything noticeable can be found as to what may be his origin. Today, Mr. Abdul Hussain is produced before the court, but it is noticed that the person is not in a physical and mental state to provide any information. And it is also stated that recently he had suffered a brain stroke, which had even worsened his condition. The present condition of the petitioner may also be taken note of while taking this call. Take your time. It may.
It will be in the end of September election.
This also instead of fixed. If any decision is taken on the petitioner number 1, Abdul Hussain, a further decision would also have to be taken in respect of his children, mainly the 2 sons. How many sons? Maybe his children, who are stated to be 5 sons. Well, in respect of his 5 sons, children are 5 sons. And whether a case-specific similar benefit can also be given to them. This also.
Deep lovely.
May I please, Lordship. Lordship, may kindly see page 17. Is Fakumi is my grandfather. His name appears in the voter list of 1966, village Borpalli,
Hakumia.
Hakumi.
Now, who is the father?
Other is Shiraz. His name appears with Hakumia in the voter list of 85, page 21.
Siraz Ali is the
Yes.
father. Hakumia is the grandfather.
Yes. Now,
Village is Boropali.
same.
Boropali. And now, who is the petitioner?
Petitioner is
Sivatun Nessa.
Sivatun Nessa,
Which
alias
material?
Siratun Nessa.
Which material?
Now, my lord, this Shiraz Ali has adduced evidence as DW2,
Hmm.
page 71.
Father.
Father.
Okay. You cross-examine the father. What else to do? Third, Mr. M.U. Mahmood and counsel for the petitioner also. The petitioner Sivatun Nessa had been referred to the Foreigners Tribunal number
1.
1
Page
Forfeiture
78.
for rendering an opinion as to whether he is a foreigner, resulting in registration of FT case number 126/2016. Tribunal rendered an opinion dated 8/11/2018 declaring the petitioner to be a foreigner. No, the tribunal passed an order 8/11/2018 rejecting the
Page 21.
opinion declaration. In the opinion of the tribunal, it is written that the predecessor of the member who had passed the order had given a judgment dated 16/3/2017 declaring the petitioner to be a foreigner. Although a stand was taken that the said judgment is an ex parte order, but the tribunal found that it was not an ex parte order and accordingly accepted the earlier judgment. Where is the earlier judgment?
Earlier than page 62. man.
The earlier judgment, in the earlier judgment dated 16/3/2017, is 62, not 62. 16/3/2017.
Yeah,
16/3/29.
sorry, my lord, page 54.
16/3
Page 54. 54.
54. We have perused the judgment, referred judgment dated 16/3/2017 of the earlier member of the Foreigners Tribunal number 1 Borpeta. Para 2 of the judgment is as extracted. Judgment 16/3/2017 is extracted. Para 3 of the in para 3 of the judgment, the tribunal arrives at its satisfaction that the proceedee, although submitted written statement and evidence in chief, but was absent during the hearing. In paragraph 5 to 6, 5 to 8, the tribunal refers to the documents produced by the proceedee to discharge the burden that he is not a foreigner. And in paragraph A, the tribunal was of the view that she is not a foreigner, was of the view that as the proceedee had not proved the documents in original, therefore they are of no evidentiary value. Accordingly, in para 10, the tribunal concluded that the petitioner failed to discharge the burden under section 9. But however, it is noticed that the proceedings continued before the tribunal, and on 29/8/2017, the tribunal entertained a petition by the petitioner seeking for vacating the ex parte order. And by the state order of 29/8/2017, the tribunal, taking note that the proceedee is an illiterate woman, and for the ends of justice, had allowed her to contest the case on merit as a last opportunity by adducing evidence. Thereafter, it appears that the petitioner had adduced some further evidence as DW1 on 7/11/2017, which is available at page 66 of the writ petition. Six, 66 onwards in the writ petition. The evidence of DW2 Siraj Ali was also rendered before the tribunal. They also appears in the records of the tribunal, which was made on 14/6/2018. Now, where is the order of the tribunal?
Last order, page 78.
But however, when the matter came up before the tribunal on 8/11/2018, neither the order dated (29/8/2018), granting the petitioner a last opportunity to adduce evidence, nor the evidences rendered thereafter as DW1 and 2 on the dates, respectively on so and so, was taken note of by the tribunal. And the tribunal deemed it appropriate that the earlier judgment dated 16/3/2017 itself was a declared judgment, and accordingly accepted the same and declared the petitioner to be a foreigner. The procedure adopted by the tribunal is unacceptable. If the 16/3/17 was the final judgment by the tribunal, there ought not to have been any further proceeding, as the judgment brings a proceeding to its end. On the other hand, if the tribunal, in its wisdom, deemed appropriate to grant a last opportunity to the petitioner to produce any material by the order dated 29/8/2017, the tribunal ought to have honored its own order. And when further evidence were rendered and documents placed, it was the duty of the tribunal to take note of such material and thereafter pass an opinion. From such point of view, the opinion dated so and so 8 is set aside, matter remanded back to the tribunal to proceed against the petitioner in terms of the order dated 29/8/2017, giving the petitioner a last opportunity, and also by taking note of the further materials and evidences that may have been brought on record by the petitioner. Liberty also granted to the petitioner to bring in any further material if so advised. The respondents in the Home Department may examine the materials produced by the petitioner and submit their report before the tribunal, raising any objection if so advised. Upon doing the needful, the reason will be passed. The order dated so and so is set aside.
Will actually appear.
Appear on so. Take a fixed date. We intend to sit with the other
Well,
bench
no,
at
no
12
problem.
o'clock.
The other day we reached
How long will it take?
only 10 minutes. 30.
10 minutes will be past 12.
Then alligator nurses.
Take it on some other day.
Yes.
List of.
Number of the village 2011, but not found in
61.
60.
This is precisely what we want.
Lordship. My lord, this was
Huh.
given. And Lordship, my lord, Annexure A, this is the old, my lord, that Kamrup. There-
No, no, in A, we are not interested.
Lordship.
We are interested only on E.
Lordship, E and also Lordship, my
And E is, it's a whole thing is a Borpeta or, oh, no, Borpeta, Bozali part, Borpeta.
This is the 5 districts of now, my lord. Buxar, Tamalpur. And also Kamrup, Mepro. Kamrup, all are included.
Just a minute. Take it along with you. Deliver it. You get a copy of this. If I use it, I'm pretty sure. Or, Who is the revenue secretary?
My lord, the principal secretary, my lord, that Gyananda.
Hmm. Can he have his presence for an interaction?
But this is done by my lord, that Ashok
No, let him do. Can we have the principal secretary for an interaction?
Lordship.
I think. Or Mr. Borman can also come.
Lordship,
Special
Lord-
secretary means?
Lordship, my lord. He has been, my lord, interested this,
I understand. Special secretary means?
my lord, he was, my lord, retired from the service, my lord, he was.
Hey, the retired person.
He already been, my lord.
No, no,
posted as
he will have only specific powers, retired person.
He has a give the, my lord, the special, the secretary. to the-
And let him do
now.
this work, but let us have the principal secretary.
Earlier, my lord, he was, my lord, in the, my lord, revenue department.
Understand?
That time, my lord, he was transferred to the, my lord, the
No,
post
but he
office.
won't have other powers. Other administrative powers he won't have.
My lord,
But the principal secretary will have a.
He may accompany.
He can accompany, no doubt. But
this person has the, my lord, a vast knowledge of the, my lord, revenue.
no, he is most welcome. We are not anything against him, but what we may require him to do, he may not have the authority to do that. We are not questioning the credibility or capability of the person. Ask him also to remain present.
Along with him.
When it will be convenient? Because this whole thing is stuck up because of this issue. We have to expedite also.
Your lordship, my lord,
For this purpose, we'll have a bench at 4 o'clock on one day. Sorry, Dr. For this purpose, at 4 o'clock, because it's not a regular bench. When will it be convenient for him to come? This
my lord, let me take the.
Thursday,
information.
this Thursday?
Let me take my, take me to take the information from him, my lord, when he is available.
Availability.
Just only the availability. We basically want the revenue secretary to just who are occupying these villages? For that information. That's why he said Mr. Burman may not have that administrative power to find out. Because he is a special secretary engaged for a special purpose only. He may not have the overall administrative powers. Your case will.
Kindly hear my case separately.
This is, we are thinking of another issue. Your case will deal with accordingly. Thursday?
Or Friday at 2 o'clock. Friday, 2 o'clock.
Friday at 2 o'clock.
Possibly.
In the meantime, my lord, I have.
Okay. We perused the annexure. We perused the list of villages marked as annexure E, containing the number of villages which existed in 2011 but not in the year 1961. For an introduction, we'd like to have the presence of the Principal Secretary, Revenue Department, Sri Ashok Kumar Burman, IAS retired Special Secretary to the Assam Revenue and BM Department, may also remain present along with the Principal Secretary. Why did he have the presence of the DGP also on the same day? Because I think revenue will need the help of the police again.
Home Department.
Home Department.
Lordship passes a formal order.
We are
So I
passing
can
the
go
order. The presence of the Director General of Police is also required. And this is for some of the districts. Other districts, you please prepare it. Give us-
This is smaller that all come.
understood.
There are 5 districts.
No, for the other districts like
But the other-
Dhubri, then Nagaon, all those. Jorhat
That lower Assam part, I already been directed.
and Dhubri also, especially.
Dhubri, Dhubri, Golpara. All of this,
Dhubri,
and
Golpara.
Nagaon and
Dhubri, earlier Dhubri and Golpara were combined into one district in the 1960s.
Golpara,
So that will include Dhubri, Golpara, Bongaigaon and Koprachar. Earlier Dhubri district. Mr. Mohindra, you do one thing. And Mr. Henry Gopsi, consult with the two officers, tell them their availability. Accordingly, we may change the date and time also. And
I will inform them.
we want to bench for hardly 5 to 10 minutes, not more than that.
Lords,
Or my lord,
Preferably, whenever it is, preferably at 4 o'clock, so that everybody can do their.
can it be done like this? They will join virtually. In that case, normally this is what's done in all other courts, so that they don't have to come here and. Then instead of 2 o'clock, it may be done at 4 o'clock, so that after the court,
Then Friday 4 will be a little dangerous.
then Thursday.
Thursday, let it be 4 o'clock.
In the meantime, we will just find out about the availability and. we
They
will
will
inform them.
tell us if they are unavailable, we can have a change in the date.
Right.
Time let it remain 4,
Fine.
other than Friday.
Fine.
Mm,
We- তোমার পাওয়ার বিষয় না depend on সেটা বুঝলাম।
Please, you can.
The formal water, I mean,
The,
copy of this one. I have to.
the list similar in respect to other districts may also be produced. कोई देखो।
Our comparison also. তখন আমি যে বিষয় দিশা হয় তবে এক্সট্রা আছে তো স্যার আপনার এটা কোনো আইডিয়া হয়েছিল এক্সট্রা আছে বিজি এতে নাই মানে যে নতুন এটি করে দিন বেশি
We'll continue up to little short of 3 o'clock, because 3 o'clock will take up one more bench is there. That's-
Right. यार ये तो पर हमको दिशा तो कंपनी है क्या नहीं तो जियाला है मैं भी बोलिए उसको प्रोफेशनल जो जी बोलिए बेनिफिट से सेट हो जे पे बस बोलिए I was making a submission on the last occasion. Great mirror. That section 3(2) of the Anti-Tax Act provides for not levying of the anti-tax in case the goods are resold
Or period judgment will be as. আৰু এগ্ৰি টেক্স এখন আছিল নহয় এটা প্ৰিন্টেড এটা এইখন নেকি এইখন This one, Assam Entry Tax 2008. P2.
C2 Milot, which provides that in case the specified goods that notwithstanding anything contained in subsection 1 and subject to production of documentary proof, no anti-tax shall be levied on such specified goods.
So we are challenging 3(1) and 3(2) both or only 3(2)?
3(1) I am challenging on the ground of
3(2).
3(2).
Because of the provision of 3(2), 3(1) is challenged.
3(1) is also challenged on other grounds that I'll place before your lordship. Now, my submissions before your lordship on the last date was that Milot, that section 3(2) provides that there shall be no levy of anti-tax.
Hey, no, it will not. Or will it?
It is state of Bihar as
We were going to go to higher tax for also.
it is. Start on 18 to grant.
Paragraph कोई सुने नहीं.
पुरान कीजिए एक कॉपी दिया
So क्यों लिखा भाई? वो बॉर्डर का सबके टैक्स ऑफ क्यों लिखने में है?
তারপরে এটাও আছে নাকি? তারপরে এটা কি দিছে তো নতুন তো এটাও আছে নাকি? কাটি নতুন বানাই আছে।
paragraphs in that Supreme Court judgment, Jindal law. I was a kind of reviews and it will embrace it.
आपको इटली दिसा
Yes, please start.
So Milo, I will making a submission for Lordship Milo. That section 3(2)
Yeah.
only provides for non-levy of tax. If the specified goods after entering into local area are resold,
It's 3-1.
3(2) Milo.
Oh, wait. একটু ঘোরাবো জানার নাই
If the specified goods after entering into local area are resold by a person registered under the Assam Value Tax Act.
so under 3-2 he will not pay the
you know,
tax.
But so far as the goods entering in the local area for consumption and use,
You have to pay.
there is no such provision is there.
Hmm.
Now, my submission for Lordship was that,
Hmm.
that since the goods entering into the local area for consumption and use
Hmm.
have been made liable to the entry tax, whereas the goods entering into the local area for resale
Hmm.
have been not made liable for the entry tax. The same is violative of Article 304A of the Constitution of India. Now, in support to that, my lord, I'm placing before Lordship a judgment of the Division Bench of Patna High Court, which was affirmed by the Supreme Court. My Lordship may. Operations was assigned. Tonight it was assigned. Hey, sir, tonight, sir, you can have us. Into a scene of the device, I think to come back. Yes.
Yes.
My lord, is judgment of the Patna High Court, my lord. At page 136. My lordship may kindly see, my lord, page 136. Para 9, my lord,
Just
at page 139.
one 139.
My lord.
para 9.
Mail. Or I may start from para 8 also. Madam. Para 8. It is to be noted that only 6 goods were listed under the schedule to the Parent Act 1993, and paddy, rice, and wheat, the subject of levy in this case, were not among the scheduled goods.
Where is para?
Para 8 at page 138.
6. Yes, it is to be noted. Huh?
Right.
It is to be noted.
Noted that only 6 goods were listed under the schedule to the Parent Act 1993, and paddy, rice, and wheat, the subject of the levy in this case, were not among the scheduled goods. Paddy, rice, and wheat were not included in the schedule, even when it was expanded by the amending Act 10 of 2001 and further by amending Act 9 of 2003 with effect from 3. But the Second Amendment Act inserted Section 3A that empowered the state government to amend or alter the statute of the Act or to add anything in by issuing a notification in exercise of the powers under Section 3A of the Act. The state government issued notification number so and so by which paddy, rice, and wheat pulses so and so were added as serial number 25 to the schedule. On the same date, the state government issued another notification bearing number so and so in exercise of the powers in Section 3(1) of the Act, fixing the rate of anti-tax on paddy, rice, wheat, etc. at 4% of their value. It is admitted position that at that time the rate of sales tax on paddy, rice, wheat, etc. was 1%. In other words, the rate of anti-tax on the goods in question was higher than the rate of tax, at the rate of 3%. Here it may recall that Indian Oil Corporation Limited versus so and so, it was argued that following the amendment of the definition of entry of the goods with effect from so and so, the act has become discriminatory against goods imported from outside the state. The Advocate General rebutted the contention, submitting that the charge of discrimination overlooked the fact that simultaneously with the amendment of the definition of the entry of the goods, a provision was introduced by second proviso subsequent to so and so for giving credit of the anti-tax levied and collected towards the sales tax payable on the sale of those goods. He submitted that the act was provided with an internal balancing mechanism that saved it from being discriminatory against the goods imported from other states. In that case, it was pointed out that at least in the case of paddy, wheat, and the rice, the rate of anti-tax was higher than the rate of sales tax, with the result that paddy, rice, and wheat imported from outside the state suffered a higher incidence of tax compared to paddy, rice, and wheat procured within the state. The Advocate General countered the submission by taking the stand that if for some goods the rate of anti-tax was higher than the rate of sales tax, then that might be a ground for challenge the notification fixing the rate of anti-tax under subsequent 1 of Section 3 of the Anti-Tax Act. But on that basis, it could not be argued that the act was itself discriminatory or violative of Article 304A of the Constitution. It thus becomes plain and clear that in order to save the act from the vice of discrimination against paddy, wheat, and rice imported from outside the state, the notification number so and so fixing the rate of anti-tax on those goods at 4% of their value must be struck down for being higher than the rate of sales tax on those goods. This is important ground on which the petition is bound to succeed. Since the petition succeeds on the 2 grounds as indicated above, it is not necessary to go into the other points raised by so and so, but I must here that leaving aside the constitutional validity of the act during the pendency of the question of legality of the notification, that is so and so, or the admitted facts of the case, I am completely unable to justify the finding that there was any attempt by the petitioner to evade the levy of the anti-tax and the consequence imposition of the heavy penalty. Further, as so and so is not. The question was that if the burden on a person is higher than the local tax. Now, I will come to the burden, that what includes the burden, whether it includes only the anti-tax or whether it includes any taxes. I will place before Lordship the judgment. If the burden is higher than the local, then it will be discriminatory in Article 30A of the Constitution of India. Now, this judgment was challenged before the Apex Court, and the Apex Court upheld insofar as the judgment finding as regards the discrimination part is concerned. The Lordship may kindly see. Yes, their comparison. Even you took this. You'll also may see kindly at page 144.
Yes.
Your Lordship, what you know.
Hmm.
The result of the judgment of the High Court indicates that it was allowed the repetition of the respondent SSC herein on two grounds which are agenda. The text was non-discriminatory in character and volatility was provisions of 304B of the Constitution of India, inasmuch the previous sanction of the President of India was not taken, and the right notification number so and so paddy, rice, and pulses, flour, atta, SLB, and basin were added to the serial number 25 of the schedule, and on the same date, while another notification number so and so in exercise the powers on the so and so, the rate of anti-tax on the paddy rice was fixed at 4% of their value. Assume that the sales tax was rice was 1%. On that basis, the High Court held that the aforesaid act is indiscriminate in nature. Insofar as the finding of the High Court that the act is violative of the provisions section 304, Article 304B of the Constitution is concerned, the same stands overruled by the 9th bench in so and so. To this extent, the judgment of the High Court is satisfied. Insofar as second issue, holding I see SO 32 of so and so in respect of paddy, rice, wheat for the period to so and so at discriminatory concern, we do not find any error. The finding on issue number 2 are accordingly upheld. The appeal is accordingly dismissed. So, my lord, in case the burden on the goods of the tax of the goods, when they are imported from outside for the purpose of consumption and use, is higher than purchased locally, that the same shall be discriminatory.
Sorry, when the burden in
Of
the
the tax.
goods on tax on the
Goods which are imported from outside
imported from outside,
for the purpose of consumption and use
consumption and use,
is higher
than the local.
than the goods purchased locally.
When the overall tax burden, you are
Overall tax, that I'm coming to you. I will also see the 9th bench judgment.
so whenever there is entry tax over and above some local tax, the burden is bound to be higher.
Not well.
So that means across the board entry tax can never be, if you accept this argument, across the board there can be no entry tax.
No.
Because whenever there is entry tax is always over and above the local tax.
No. No, I'm saying entry tax and other taxes, apart from the local taxes. The goods which when I'm importing from outside,
Huh.
I have to pay the entry tax as well as the CST.
Okay, you are comparing with CST now.
CST.
Huh.
I'm saying that the burden is not only of entry tax, while
Hmm.
considering 304A, the burden of only entry tax is not to be seen.
Hmm.
The entire burden is to be seen, and that regard, my lord, the 9th bench judgment,
The Jindal,
my lord,
that
Jindal,
Jindal line.
Jindal. And that next time you will also see the judgment of Justice Chandrachud.
Hmm. Paragraph number
At page 459,
459.
my lord. Para 691.
Paragraph number?
691. Page 459.
691.
While
Hmm.
this is exemption and incentives. A bench of two judges of this court in Western Electronic versus State of Gujarat dealt with the validity of the exemption granted under Gujarat Sales Tax Act. A notification was issued under section 49(2) of the act, by which sales tax on television sets imported from outside the state was fixed at 10%, whereas it was 1% for the goods manufactured within the state. Adverting the judgment of the constitutional bench in Mehtab Malik, a bench of two learned judges stated the defense of the state that the rate of tax was reduced for locally manufactured goods by way of incentives, placing reliance on clauses B and C of Article 39 of the Constitution. This, in view of the court, did not provide a justification for a distinction between the imported goods and the goods which were locally manufactured or produced. The prescription of a lower rate of tax for the latter was held to be invalid. This court held in Western Electronics as under. An exception to the mandate declared by Article 301 and the provision contained in Clause 1 of Article 303 can be sustained on the basis of Clause A of Article 304 only if the condition contained in the latter provision are satisfied. In the result, the discrimination affected by applying different rates of taxes between goods imported into and state of Gujarat and the goods manufactured within the state must be struck down. I will also skip over and may come to 475, page 475.
470. So here what it says that defense of the state that the rate of tax was reduced for locally manufactured goods by of incentive did not provide a justification for a discrimination. This is what is 491, the 691.
So they say that only for the ground that the locally manufactured goods, because as I submitted earlier also, that for a limited period, 5 years for development, you can give it. But one cannot say that we for locally manufactured goods, we are giving an incentives and thereby giving the discrimination. That's why it was struck down.
Incentive means?
An incentive for the new industries like for 5 years, 6 years. It
Incentive is something you are required to pay, but because of the incentive, that requirement is withdrawn for some time being.
for some time, being.
Ah.
But it
So
cannot
that
be
is incentive.
incentives or exemption or whatever I might say.
But
But a general,
imposition and not imposing on some other aspect, that is not an incentive.
no, look, in the local industries where the exemption industrial policies are announced,
Understand?
there where the, it
No,
says that-
these incentives, what we have come across, suppose this excise duty. Northeast policy. Excise duty is suppose 10%. For the incentive part, for the new upcoming industry, they give an incentive that you pay 4% or you don't pay at all. This is incentive. This otherwise under the law you are required to pay. But because of the incentive, either you pay less or you don't pay at all.
but here,
Huh.
the locally manufactured goods as a general,
Hmm.
as a general was given incentive for the local university, what it said.
Yeah, the page
The-
471.
459,
The same one.
my lord.
Ah.
What it will contain,
Hmm.
that the notification with sales tax on television imported from outside the state was
Was
fixed at
fixed on
10%,
10%, whereas
Whereas
it was
it was
1% for
goods
goods
manufactured
manufactured
this
within the state.
adverting to the judgment of constitution bench, a bench so and so, the noted the defense of the state that the rate of tax was
Imported is
reduced locally
10%,
manufactured goods by way of incentives.
manufactured within 1%.
So for the locally manufactured goods as a general, as an incentives, it was reduced to 1%. And that was struck down. That as a general, you can't do it.
Yes.
Now you'll also come to page 475. Whereas 728. Eh, 725 million, I'm sorry. Equality of tax burden,
728.
725 million.
Right. 725.
My lord.
At first instance,
At first instance, Article 304A presents a fairly simple application. If a tax at the rate of 5% is imposed by a taxing state on goods imported from other states, similar goods which are produced or manufactured within the state must be subjected to 5% tax. If a heavier rate of tax is imposed on the goods originating from the other states which are imported into the taxing state, this would result in discrimination against imported goods. Such a discrimination sought to be obviated is the requirement that the rate of tax should be the same in between the similar goods produced or manufactured within the taxing state and goods imported from other states. This furnishes the rationale of several decisions of this court, which hold that Article 304A mandates the same rate of tax, and once that requirement is fulfilled, the application of the provision came to end. Now we'll also come to page 728. A state may have a single legislative enactment providing for both entry tax and the sales tax at equal rates. Some other states provide for set-offs and statutory exemptions to goods paying local sales tax. Certain states provide a similar set-off for goods imported from other states if they are sold in the taxing state. The legislation of some state provides for a reduction of the tax liability under the sales tax law by the amount of entry tax paid in other states. State legislation provide for reduction of the entry tax by the amount of tax paid under the Central Sales Tax Act, General Sales Tax Act. Similarly, the state enactment provide for the reduction of the liability under the entry tax legislation by the amount of tax which is paid under the sales tax law of the state. Contrarwise, such a reduction has not been made available to imported goods in certain state legislations. The state legislations have excluded from entry tax those local goods which they are liable to sales tax under the State Act.
para 728.
My lord. The last line is also similar. The state legislations have excluded from entry tax those local goods which are liable to pay sales tax under the State Act. This is a similar situation in our case.
This is similar.
However, an importer of scheduled goods who incurs liability under the value tax legislation by virtue of the sale of imported goods or the sale of goods manufactured by consuming such goods is entitled to a set-off. The state legislation in certain cases exempts goods from entry tax if after entering the local area, the goods are sold there and become liable to pay the value-added tax. In other cases, manufacturer
In certain cases, certain exempts good from entry tax after
if after entering
entry
in
in
the
the
local
local
area,
area,
the
the
goods
goods
are,
are sold.
that is the same case, in our case. In other cases, manufacturers in a local area are exempt from paying entry tax on raw materials imported from other local area or other states. In some cases, manufacturers in local area are required to pay the same entry tax on raw material imported from other local area or another state.
This is basically a description of what is provided in 3.1 and 3.2.
My lord. That is, I'm.
In other words, what is provided in 3.1 and 3.2 is described in 728.
My lord. Now we'll also see paragraph 730. Article 304A, insofar as material, authorizes the legislature of the state to impose on goods imported from other states any tax to which the similar goods manufactured or produced in that state are subject. Several aspects of Article 304A merit emphasis. The first is that Article 304A refers to the imposition of any tax on goods. The provision is not either a source of legislative power, nor does it prescribe the field of legislation. The expression any tax on goods is of general nature and covers all taxes which a state is competent to impose on any aspect of the goods under Article 245 to 46, read with at least 2 of the 7 schedule. The expression any tax would mean the extraction of the nature of an imposed or levy which the state legislature is competent to enact by virtue of its legislative powers. The expression any tax must mean what it says it means any levy which the state is constitutionally competent to legislate. In the bottom below. The fundamental reason for the incorporation of the provision is to prohibit discrimination on being practiced by the state against imported goods by embarking upon the protectionist policies the discrimination which the constitutional provisions is intended to rule out is the discrimination which is protectionized in nature. A state cannot impose taxes in a manner that would make the goods of another state non-competitive so as to be effectively for the inflow of the trade by utilizing fiscal restrictions.
Yes.
Now, at para 730.3. Therefore, the later part of Article 304A is prefaced by the expression so, however, in words and phrases, the expression however has been explained as indicating an alternative intention, a contrast with the previous clause and modification of it in circumstances. The Oxford Dictionary defines the expression however to mean in any case, at all events, at any rate. Another meaning attributed to the
Yes.
phrase
304A impose on goods imported from other states
Milo.
or any tax to which similar goods manufactured or produced in that are subject. So, however, as not to discriminate between goods so imported. Yes.
730.3 Milo, the last 7 lines, paragraph. The later part of Article 304A follows upon the first, which enables the state to impose on goods which are imported from other states any tax to which the goods produced and manufactured within the state are subject. The latter part constitutes a positive reaffirmation that in any case, in all events, and at any rate, there shall be no discrimination between the goods manufactured and produced within the taxing state and goods imported from other states. This is narrative of the scheme of Article 304A. Now we also may skip over and may come to my lord, paragraph 732. As a matter of constitutional doctrine, there is no restraint on the plenary powers of the parliament as well as the state legislature, which requires the legislative body enacting the statute to legislate only upon one head of legislation falling within the competence. The legislature can distribute or allocate its mandatory, regulatory or law-making power both to local and non-fiscal in nature, which best serves the needs and concerns. Once this be the position, its impact upon the interpretation of Article 304A is that it is open to the state legislature to have due regard to the equality of tax burden when it legislates to impose any tax, so long as it does not breach the notion of non-discrimination as between goods that are imported from other states and goods which are produced or manufactured within the state. It is legitimately entitled to ensure that the tax burden should not be discriminated between the locally produced or manufactured goods over from. Once there is no discrimination necessity, to the form in which the legislation is enacted in India must cover only one legislative entry. The legislature is entitled to devise a law in a suitable manner, which while being consistent with the form of the non-discrimination also preserves the parity of tax between the goods imported and domestic goods. This is the foundation of the theory of equivalence. 733. The burden of establishing that there is a discrimination. My lord. The burden of establishing that there is a discrimination against goods which are imported from the state lies on the person who sets up such a plea. In answering the plea of discrimination, it will be open to the state to establish the legislative provisions which it has enacted pertains to the principles of non-discrimination between goods produced and manufactured within the state and goods imported from other states, while at the same time bringing about parity in respect of tax burden between the domestic and the imported goods. Sales tax is referable to entry 54 of list 2. Taxes on the sale and purchase of goods and newspapers subject to the provisions of entry to 92 of list 1. Anti-tax is referable to 52 list 2. Taxes on the entry of the goods into local area for consumption, use or selling. Both sales of taxes fall within the competence of the state legislature. Taxable events under both the entries are distinct in the case of one sale of goods and in the case another entry of the goods into a local area for consumption, use or sale therein. Both deal with separate aspects of the taxation of the goods. The taxable events being proximate though distinct. The expression any tax recognizes the full panoply of the taxes on goods falling within list 2. If the law can cover entry 52 and 54 of list 2, there is no reason to prohibit the state law making authority from having due regard to tax burdens imposed on the domestic goods and the goods imposed on the other states and the anti-tax and the sales tax legislations taken as a composite whole. Any tax does not mean a tax under one entry of list 2 as a discrete and isolated legislation independent of the another entry. Any adjustment, exemption, or set-off based on the payment of sales tax may be intended to avoid double taxation and discrimination. Whether this object has been legislatively achieved by enacting the law is a matter to be determined on its interpretation and application. Pausing here for the time being.
Mhm.
That the, in your lordship's words, not levying of the tax,
Sorry.
not levying of the tax 3(2)
Hmm.
on the goods, imported goods for the purpose of resale,
Hmm.
and no granting of such exemption in respect of the goods which are used and consumed within the state. My lord, this, in my humble submission, the last part of this paragraph, which it says
734.
733,
33, whether this of the legitimately achieved by enactment is a matter determined in its interpretation and application.
parity of the burden. I am not here in the case of the my lord for resale.
Hmm.
I am in this case is for use and consumption. Whether the burden in respect of the goods which are purchased,
So your basic contention is you cannot discriminate the goods for consumption and goods for resale.
use,
If you exempt goods for resale, you have to exempt goods for consumption also. I think this is what
Right.
you, and to substantiate that, based on this principle of that there must be equality of the tax burden, total tax burden.
now your lordship may kindly skip over and come to page 486.
This is the minority view or accepted by all.
My lord, in fact, this part has not been dealt with by the other honorable judges. 304A is not discriminatory. This much has been said.
No, otherwise, how will you have to read this part of the judgment?
My lord, because you will also find,
No, it holds the field or it is a minority
my
view.
lord, in my humble
Because
submission,
sometimes minority views are the best view, which ultimately in a later judgment is again, that is
my
taken.
lord, in my view, the other general judges have not disputed, not
Hmm.
dissented with it. They have said the 304A, the discrimination should not be there. Here, the view is only explaining that what is discrimination. They not saw that the law is there, the discrimination should not be there.
Hmm.
But in what way the discrimination,
In
way
what manner there can be a discrimination, this is,
Discussed.
that has been explained.
explain. So it cannot be said, my lord, that the view which has been expressed by Justice Chandrachud are dissenting to the.
It's basically clarification or expansion of what has already been expressed. This is
The-
what you're trying to
The
say.
dispute is not, it has been held by everyone. That the
No.
discrimination,
This part
my lord,
merely explains or expands what has already been provided.
my lord.
So it is not a dissenting.
In my humble submission, it is not a dissenting. Because you'll also find that it's in the earlier part, it says partly concurring, partly dissenting.
Hmm.
It started to. Because there are other points which are there, my lord.
Hmm.
That will be about Article 286 of the Constitution of India. Apart from the other judgments which I place in support of this. Because in one of the cases, it is a peculiar one, my lord.
But again, the question that I asked is still troubling my mind. It's not troubling exactly, it's still going on in my mind. If you come to page 730, para 732,
My lord.
the principle had been explained in 733.
My lord.
No, just between placitum E and placitum F.
My lord.
It is again, so long it does not breach the notion of non-discrimination as between goods that are imported from other states and goods produced or manufactured within. So here is a case, local area is, different local areas are within the state. This tax is imposed in respect of a goods entering one local area from another local area. It's not related to one state to another state. In fact, the goods manufactured in the same state, if it is manufactured in another local area and enters the other local area, then also this tax will be applicable.
My humble submission.
So, entire basis is of this explanation and expansion and clarification is in respect of goods entering one state to another state. The goods entering from the other state is imposed a tax, goods manufactured in the state is not. But here is a case, even the goods manufactured in the same state is also subject to the same tax.
If one local area to another local area, assuming I am purchasing from one local area to another local area,
Huh.
then sales tax will be payable. My lord, you'll also may kindly see, my lord. If the goods are sold, the exemption. in
No,
respect-
no, suppose a goods manufactured in one local area is brought into another local area and used for consumption. They'll have to pay this entry tax. So, meaning thereby that the goods produced in the same state are also subjected to the same tax.
But he has not to pay the central sales tax. The tax.
So
burden.
ultimately, you are delving on the
Burden.
on the concept of overall burden.
Overall burden. The question will be overall burden.
Okay.
So what is the overall burden of the tax on a person who is importing from outside? Whether that in fact,
So the equality of tax burden on the 733,
my lord,
there is no reason to prohibit the state lawmaking authority from having due regard to the tax burden
my lord.
on domestic goods and goods imported from other states. So this equality of burden is also in respect of goods imported from one state and manufactured in one state.
Right.
But if the basis is now changed to, I think they have done it very intelligently, therefore. Instead of putting it from one state to the other state, impose
that-
entry tax,
That cannot be done because my lord,
they have, what they have done it, they had made the entry tax on the basis of local areas.
so that has to be because the entry tax,
No, and in one state, there are several local
because
areas.
the local area, my lord,
So a local area manufactured in one state of one state is also subject to the
because
tax.
my lord, the entry itself says anti-tax will be levied on entry of goods into a local area.
Local area.
So local area, now one cannot say that the state, entire state is a local area. They cannot. say.
No, they have divided into different
That's
parts.
why they have divided.
So if the local area A in Kamrup imports a group from local area B in, say, Jorhat, they are subjected to this tax.
Absolutely.
Once they are subjected to the tax, then the tax imposed on the goods manufactured in the state is also subject to the tax.
If-
Goods imported from outside the state is
In case-
also subject to the
In
tax.
case the burden of the tax,
And that's why, no, this principle of burden is evolved only on the basis of whether you are importing from another state or not.
my lord, I will come to that, my lord. It says imported goods and local goods.
No.
Imported
Dr.
goods.
Saraf, what your submission, I'm understanding.
Yes, my lord.
Only thing that had this 3-1 been structured in a manner that the entry of goods into any in the state
Now
and
that-
or the local area, the whole of the state is one local
Then
area.
it will be very easy for us.
And
for
then
getting-
everything would have been over
it
in
will-
one
it
stroke.
will one
Means,
half an hour hearing.
in fact, from your part, I would have closed the hearing by
Well,
now
for half
because
an-
it is already clinching.
In 1 hour, my lord, your lordship would have stuck down it.
Lordship,
But-
local area has been defined.
Yes, yes,
And-
I never said, very beginning I've said that.
Sure,
if I-
Therefore, we are asking. Okay, we'll come back. What kind of mention?
Mention lordship, in fact, yesterday the matter was moved. It was fixed today. Pertaining to criminal division bench. And when the matter was not listed, we approached the judicial registry. Usually what they do is take out a production list and list the matter. Then they informed us that we should make a mention before the, yes, lordship, the earlier division bench. That is what I'm on. And lordship, I came to the court for mentioning. Then by the time the court was in session,
Instead of going to rescue, you ought to have followed the notice.
lordship, as it is, there was a judicial order.
Understand?
Yes,
You ought to have taken note of the notice in the morning and made a mention. You ought to, taking note of the notice, you ought to have made a mention.
lordship.
In
I
the
was so-
DV2, mentions were made, we entertained the mentions. It's not that no one had made a mention.
Lordship, there was a confusion.
Your,
because
but
there
how
was-
your
yes.
confusion can be addressed now? So let us go with her hearing. And that is a authority given only to the DB2. This is not the DB2. This is the difficulty.
That is why we approached the registry.
You may
of
have
the case.
approached,
Yes.
then get a notice from Honorable Chief Justice that even this bench can take up. We'll take it up.
Lordship, I'm sorry, but they clarified that we can make a mention. That is why I'm before the.
Ask the
It's
registry
okay,
how they
it's okay.
can they clarify when
It's-
something is not provided.
It's okay. That is why I was.
If they
I-
clarify, ask
I-
them to come with a notice.
I'm sorry.
We'll definitely, we have no difficulty in entertaining your petition. We have no difficulty in hearing you. But only thing, it should be authorized.
Yes,
Where
only-
is that authority we have?
understand. That is only because they.
And
clarified that I can
somebody in
make-
the registry clarifying you will not grant you authority.
Yes, the registrar himself, he said that is why.
Yeah,
Okay,
Registrar
Lordship,
Madhav.
I'm sorry. Yes, Mr. Chinmay Boga, I approached.
Ask the register under what authority he says, we can take up. That's good. Let's give back the notice. We have seen that notice in the morning. In fact, also looked at, waited for a couple of moments also to see if there is mention of that other bench. It was not there. Yes, Professor.
My lord. May place before lordship, my lord, para is 486,
486.
para 750.3.
This, what you have read till now, we have understood and we are fully with you. That is the only difficulty, whether these propositions, we can also make it applicable to the present circumstances. Once we cross this barrier, everything is there.
Proposition of this one, my lord. But in case.
That will fall on its own, it will fall
In
through.
case you also find that the 9 judges in any of that. has-
Aha.
in the majority.
No,
view,
no, this is a proposition entirely based on goods entering one state from another, goods manufactured in the same state. It's a proposition entirely based on that. But here is a case, they're not imposing the tax on goods entering the state, but they're imposing the tax goods entering a local area.
So this case was.
So
This-
moment we cross this barrier, each and every paragraph can be adopted, and the proposition we are fully agreeing with you, and I think we have understood also.
With due respect, I Mr. Biplab, this in general stainless, the court was dealing with the anti-tax matter by anticipating anti-52.
Entry tax of which state?
Different states were there, even Assam was also there.
Was the local area?
The anti itself, you also may see, anti 52 of list 2. You also may see,
Once you can establish that link,
anti 52 of list 2,
entry 52 of list 2.
the 7th schedule.
Entry 52.
Well,
That is, I think, deleted.
now deleted.
No, now deleted.
Well-
Entry 52,
Yeah.
taxes on the entry of goods into a local area for consumption, use or sale therein.
This was the subject matter. They were anticipating anti 52.
Then how 304A was brought in? If it's a entry tax under entry 52 of the list 2, then how the concept of 304A was brought in?
The local area is also within the state. Now, the state, when you say, it's not necessary that in one local area, another, the goods are entering a particular state first.
This is,
Because you'll also find that the court has also dealt with in the earlier part when I read that anti 52 list 2, anti 52, 54 of list 2.
but let us read 304A once again.
You'll also, before that,
Restriction notwithstanding anything contained in 301, freedom of trade subject to the it shall be free. 303, ending at 302. One state over another. Or making authorizing making only this will be one state.
otherwise, my lord, the 304A will not be applicable at all.
No, it would have been applicable had section 3(1) say that entry tax is applicable to goods entering the state.
No, I'm saying, the
And or had they defined local area to be the boundaries of a state.
in all the cases, it is entry, otherwise entry tax cannot be imposed at all.
Entry tax may tax into a local area, and a local area means
Entry tax can be made applicable only when
mm,
the goods are entering into a local area.
local area means any area of the state. within the limits of any local authority, municipal corporation, municipality, town, gaon panchayat, Anchalik Panchayat, North Kachar Autonomous Council, or any other local authority by name called. Come out with this one. Or any other local authority by national constitution. I'm not supposed to be a no. We cannot interpret that this is the whole of the state. The moment it is received the definition. And this is subject to the other provision shall be never covered into tax and NPS specified into any local area. The Guwahati municipal or locality for the season local area that even the goods community manufactured in the state is also subject to the same law. What is subject to the goods in the state? So, fines. Junk football. Borban football. No, Borban football. So, the young was able to get a whole level. Important for freedom of subject throughout the country. Freedom to restriction, not extending one state. Preferably a state. Not extending these states are the state. The states, all Indian territory. The state of the
This one, Borman.
Dr. Saraf, yes.
My lord,
Here the register,
Yes,
please come. You say the register had clarified that even
Yes,
this
yes.
bench can accept a mention.
yes, lordship.
Did you say so? So your presentation before the court is wrong vis-a-vis the register who had openly stated before you. Yes.
Lordship,
No more explanation. You take it up. We are in the middle of a hearing. You made a submission that the register had clarified before you when you approached that even this bench, the mention we can take up. We had some doubts. So we called the register that did he make such a clarification? Register openly says he had not made that clarification.
lordship, I still stand by what I have said, lordship. I'm very sorry because
See,
that
this
is
is
what.
a live proceeding. Both
Yes.
your statements are recorded. We'll make an inquiry.
Lordship,
And if the result of the inquiry is wrong,
lordship, I'm
Section
ready
will
to
also
face,
take it.
I'm ready to face any consequences. of that.
my lord, what I was submitting for lordship. Jindal Stainless
Hmm.
was dealing with the cases of anti-tax of different states. And the different states were legislating
Yes, Professor.
Well, if your lordship kindly see page 122 of the judgment.
Of this chapter.
Well, there are two, my lord.
Hmm.
In exercise of the legislative powers under Schedule 7 list 2 entry 50 to the Constitution, several states in the country, at least 14 of whom are parties to the present proceedings, have enacted laws to provide for levy of tax on the entry of goods into local areas comprising the states.
Yeah, this is what we are saying. Local areas comprising the state.
Well,
Here is a case, they have, this definition is giving trouble. 2G definition.
we say the local area, which is
Hmm.
now comprising the state means,
Comprising the whole of the state.
no,
Yes.
your lordship kindly see it after your lordship.
The considerable is a question.
Comprising of state mean doesn't mean that the entire state is a local area. Your lordship see,
But here they have a specially made, not the entire area to be local areas, but every local area is under the Guwahati Municipal Corporation. This is one local area. Municipality or town constituted under different municipality, different local areas.
it has to be, otherwise, my lord, they will have no power to levy the entry tax at all. If they say that we are imposing entry tax on the goods imported in the state, there will be no entry tax. Because entry 52 specifically says entry of goods into a local area.
No, this is what the difficulty. Local area means any area state within the limits of any local authority.
My lord,
So every local authority will be a local area.
you know, every like municipal corporation or something
Ah.
areas, these will be defined. as
So
local
how
areas.
can we, are we to understand that every local areas under every local authority is one comprehensive local area?
Yes. It has to be, otherwise, my lord, from one local area to another local area, when we say, there will be no meaning. When the goods move from
Yes,
one,
Mr. Chaudhary, how do you understand local area? Can you place the records of any levy of any tax where one local area under a local authority, from that local area, the goods was imported to another local area that you have imposed the entry tax? Can you produce any such record? That will give an indication how you understood it. If every imposition of the tax is for a goods that came from outside the state, and it is not imposed on a goods which entered from one local area to another local area under the control of one local authority to another local authority, then Dr. Saraf may be right.
you know, in fact, this was the earlier,
But if you have imposed, then your understanding is also that every area under one local authority is a local area. Because otherwise, how would you interpret it? Only way you can interpret is how you understood it while implementing it. Fine. Entry of goods into local areas comprising the states means individual states.
you know, in fact, this issue came up before this honorable court. Earlier, from one local area to another local area, there was no entry tax. This honorable court, I have not put judgment. It was held that no, this will be violative of Article 304A. Thereafter, in 2008, the amendment was made. That if from one local
No,
area,
otherwise, every aspect you are arguing, we are completely in agreement with you.
no, I'm just trying to clarify
Ha,
that what is.
Provided we have some material to understand that the state as a whole is a local area.
Lord, I will satisfy your lordship from the judgment of division bench judgment of this honorable court.
You have it now or later?
That the same issue was raised,
Huh.
that the amendment was not there. And thereby, the court held that no.
Suppose the other division bench understood it to be otherwise. Given something and because of that, this amendment is brought in,
I think so.
then are you also to understand it the same way?
In the way, my lord, I am trying to project.
Because best is, Dr. Saraf,
My lord,
why don't you call for the records? If,
if they file an affidavit saying that there is no tax.
no. Instead of affidavits,
My lord,
give us one imposition of a tax. Where you have imposed the tax when the goods entered area under one local authority to another local
that
authority.
will, in my humble submission.
If that is produced, then
Assuming they have not imposed,
then
assuming they have not imposed, but the act provides for it.
no, then they have not understood it that way,
No, it
if they are
cannot
not
be-
imposed.
It cannot be because, my lord, if.
And but on the other hand, they have imposed from goods coming from another state. That means they understood it to be state only local
My
area.
lord, in case it is, assuming there is levy is there,
Hmm,
and for some purpose or that they have not collected,
hmm.
that will not make that the law is not there.
But then now how do you read it?
Well, I place before lordship the judgments.
Got it? Because other than this, most of your arguments we are accepting.
But from one local area
Hmm.
to another local area, crude oil is sent. From one local to another local area. For that, they made a provision for levy of tax.
You have the name of the parties or citation or anything?
I just to find out.
Yeah, give it, we'll take a print out. No, the conflict in it, thank you. Specifically defined it. Right, you're wrong. Section I say local area. So the meaning of the word local area, appearing in this section will have to be read to be unavailable in the definition. Otherwise, the local area can also be given a different meaning. But the legislature deemed it appropriate to define for the purpose of this statute. But this statute will to an extent not the general definition. Or is it you?
Was space para 65 years. I'm just giving the judgment, no?
It will be party's name, you can get it from everybody.
For the timing below your loss, para 65.
There are 60.
That matter,
Your lordship sees definitely.
Mr. Ken Chaudhary appeared for the appellant as he is described as AAG later on.
He was AG, so,
And Mr. Doctor,
you know, myself appeared and the.
no, your name I have seen. Who is Mr. Doctor? Mr. N. Doctor?
And the,
For whom did he appear?
for one of the petitioner, my lord.
Petitioners. No, we are saying because there is one line is there. Article 3 therefore requires imposition of a non-discriminatory tax so that no discrimination between the goods from imported other states and goods locally is or produced. It does not provide that the goods imported from other state or Union cannot be subjected to tax unless such goods are manufactured or produced in the state. Such an interpretation sought to be given by Mr. Doctor cannot be
No,
accepted.
that was argued that, my lord. If the goods are not manufactured, then you cannot impose the entry tax at all.
Huh.
That was rejected, that
Hmm.
it not necessarily the goods must be produced. Because,
Then if you produce, why do we import that?
you know, if I produce here,
Huh,
there is
that's-
no bar that I will not import.
So the argument was if it is produced here, you also import, then you cannot impose.
He says now, if the goods are not produced,
Huh.
the entry tax at all cannot be imposed.
Okay,
The goods at
if
least,
you produce here and also import, then you can impose it. But if you do not produce the goods at all,
my lord,
only you import,
the reason was that,
then you cannot impose.
The
That
reason-
that was
the
rejected.
reason was that 304A said,
Huh.
similar goods manufactured
Manu-
or produced.
So Mr. Doctor thought that similar goods is not produced, so it is not.
So that was rejected by the 9 judges also.
Hmm,
If your lordship looks into section 2B, my lord,
hmm.
for time being, 2B of the act,
This act. No,
Entity-
the present one,
present one,
2B,
2B, entry of goods.
entry of goods into a local area.
My lord, your lordship.
Only the entry of goods as specified into local area from any place outside that local area,
Including,
including a place outside the state.
so,
So main dominant purpose is outside the local area, and outside the local area will also include,
the
Outside
outside the
there.
state,
but the earlier definition was different. Earlier definition is entry of goods into a local area was defined as entry of goods specified in the schedule into a local area, means any of those 5 patches of local area from outside the state.
that's why it was said that you cannot.
Therefore, it was said that 304 will be applicable.
Well, now here you also see, it says entry of goods into a local area, including any place from outside the state.
So it doesn't matter from where it comes,
No,
including outside means any local area as defined in 2G, which will also include anything coming from outside the state. So now here the imposition of the tax is an entry tax on the entry of special into any local area, which irrespective of it is imported from outside the state
Or
or it
another
is
local-
brought in from another local area, moment you enter one local area
my lord.
from another, it will be imposed.
And
So
it-
this is what we are trying to
you see,
understand.
further clear, my lord. If you also-
So a good that is manufactured within the state in another local area will also be subjected. Once this is subjected, now when you read 304A,
Right.
impose on goods imported from other states any tax to which similar goods manufactured in that state are subject. So here, a similar goods manufactured in this state is also subject. So this condition is not satisfied. This is why
my lord,
we are trying to ask this question again and again.
What I was trying to say,
Hmm.
that the Chandrachud judgment you also signed, justice
Hmm.
Chandrachud, that the financial burden, total
Understood.
burden,
So entire conclusion of total burden remaining the same is on the premises that the goods are imported from one state to another. But if so to understand 304A, now 304A itself says that if the similar good manufactured in this state is not subject to that burden, but a similar good imported from another, then the restriction under 304A will come. But what will happen if the same burden is also imposed on a good which is also manufactured in this state?
There's no problem for that then.
So therefore, 3.1 also imposes a similar burden on goods manufactured in this
That
state.
is only entry tax, my lord. That's why I'm trying to insist. That is-
Understand? We are examining entry tax only. So once this is done, the bar of 304 is not applicable. We'll have to test it from another point of view. So the bar of 304, in the bar of 304, only the principle have been involved that the entire tax burden will be the criteria,
My lord.
not the value of the individual taxes.
Right.
So to condition precedent to invoke 304A is goods manufactured in this state should not be subjected to the same burden or same tax. Only then 304 is applicable. Once 304 is applicable, we have the concept of burden, actual burden, irrespective of the number of taxes.
I know.
So once the condition precedent itself is not there, even the resultant principle of equal burden is also not there.
My humble submission.
This is what we are trying to understand from you.
You'll also find the Justice Chandrachud judgment, it clearly says that tax does not mean one tax. You have to
Understand.
see the total
But
burden.
Justice Chandrachud judgment also, if you read paragraph, (732),
My lord.
this entire principle of
My lord.
tax burden is in para 733.
My lord.
Para 733 follows 732.
My lord.
732 says it does not breach the notion of non-discrimination as between goods that are imported from other state and goods manufactured or produced within.
My lord.
Again, we are back to the same principle. So when a goods manufactured within is not subjected, goods manufactured from outside the state is subjected, in that case, one of the criteria to determine is also tax burden. Tax burden on the cumulative effect of all the taxes that is applicable.
My lord, in fact, that is the, I will place before lawsuit. That is the normal discrimination.
So moment a goods manufactured, similar good manufactured in this state is also subject to the same tax, 304 is not applicable.
No, my lord. In
And
fact,
moment 304 is not applicable, all the legal principles
okay.
evolved in respect of 304 will also be not applicable.
In my due respect, irrespective of counsel, my lord, I will not. be-
Only thing, this is what.
My lord, you also may see the judgment in, I gave a comparison.
So do we have any proposition
My lord.
where
My lord.
this issue is answered, that even if goods manufactured within the state is also subjected to the same tax,
My lord, you also may kindly-
along with goods imported from other state,
Well,
then also the bar of 304 will be applicable.
I place before lawsuit, my lord.
Because the core foundation of the challenge is 304 is violated.
Right.
304 is violated.
You will also may see the judgment.
So to sustain that argument, first we have to examine whether 304A is applicable at all or not.
Absolutely correct.
Only then we'll go forward on the propositions as regards 304A.
Absolutely correct, my lord.
In the other one, had it been the 2001 Act, we would have been with you,
My lord, also may see, my lord, the judgment.
we
of-
would have been with you by now.
My lord,
Because in the other act, the concept was NGO goes into a local area from any place outside the state. So the distinction between a goods manufactured in the state and the goods imported from outside the state was retained in the earlier act. So if this distinction is retained, then it will be barred by 304A.
Lordship, see page 58 of compilation I gave one today. Array, actually compilation, but this is page 58, yes.
Page 58.
Page 58, that is state of Uttar Pradesh versus Jayaprakash Associates.
Uttar Pradesh versus Jayaprakash. Huh.
And we will also come to page 76.
Yes.
Para 38.
38. 304 ensures only equal rate of tax for incoming goods. So if such goods are taxed at a higher rate or where they are taxed at any rate, when indigenous goods enjoy concessional rate. So they are again
No.
same thing.
Article 304 is selected. They are simple case of hostile discrimination.
Yes, when?
You know, Mr. V.
No, it will happen only when goods are taxed incoming. So if goods are taxed at a higher rate or where they are taxed at a rate when indigenous goods enjoy concessional rate.
Definitely, Lordship.
So any indigenous good manufactured within the state will be subjected to a lower tax. Any goods, similar goods imported from the outside the state will be subjected to a higher tax. 304A will be applicable. And once 304A is applicable, all these propositions will be squarely applicable. So,
You'll also see the next line.
therefore, whether a party is discriminated with the minimum, the effect of the tax on the flow from outside the state has to be taken into consideration over.
And if the overall effect of the rebate of tax is such that they fall within the meaning of concession rate of tax, a detailed discussion on the effort rebate is done in the following paragraphs under the issue 2 of the judgment. Now, what is the meaning of all those things? That is, in issue number 2.
Did the 9 judge bench ultimately answer para 728? Because para 728, one line is there, the state legislation may have excluded from entry tax of those local goods which are liable to pay sales tax under the state act. This is similar to section 3(2) of the present act. What is the conclusion regarding
Conclusion,
728?
it has been left
Open
to the
discretion,
to the regular
to the
bench,
wisdom.
to the regular bench, and regular bench said that it will be the High Court will have to decide.
So we'll decide that now. We're ready to decide.
Now, Lordship may kindly see.
Because Mr. Chaudhary, one thing also we are not understanding to a great extent. Why do you distinguish between the goods consumed and goods for resale? Is there any rational basis for it?
That's what we try to explain.
If the goods is bought for consumption, consumption means it will be used as a raw material to produce something else. Definitely, that is the consumption. Definitely, the importer will not eat up everything. But the same goods, if it is used for resale, the person importing sells it to another person, then you are not liable. In that case, the person consuming it will be saved.
Yes.
Suppose today you are the importer. Dr. Saraf is the person who procures the good on a resale by you. He is the purchaser. Okay. And the goods ultimately is consumed by another person. Now, no entry tax, although it is consumed. Why? Because there is one intermediary transaction of there being a resale. But if that man directly consumes it, you'll be subject to entry tax. This possibly question was raised in para 728, which Dr. Saraf said it remained unanswered.
Lordship may see para 62 at page 82.
This one. No, that is okay. This will violate. This will violate 304.
Here what is happening, Milo? Here what is happening? Here also the similar situation.
How?
If I purchase from outside for consumption,
Huh.
the anti-tax is there.
Hmm.
If I purchase locally for consumption, anti-tax is not there.
Hmm. No, it is not on consumption. The criteria is the manufacturing.
Milo, consumption,
If you consume the goods manufactured here, you will not pay
that's the
entry
apex
tax.
what I said,
Huh.
manufacturing is not needed.
No, but 304 is what is
The word has been
manufacturing?
used, but it says manufacturing production is not necessary.
Then where is the judgment?
That is the
Where the manufacturer is not necessary?
You will also see the judgment of the
Non-judgment.
at page 621 conclusion.
Which one?
1159.7.
17. And tax on entry of good in local area of sale or consumption therein is permissible, although similar goods are not manufactured. So this is the argument of Mr. Dotto in that other case.
That was that if the similar goods are not manufactured, you cannot levy the entry tax.
This is what is
If
reiterated.
they are not manufactured,
Uh,
then entry tax, it says, can be levied.
Are not produced. Produced and manufactured, same thing.
Mr.
There cannot be
Datto-
production without
Mr.
manufacturing.
Datto argued that if certain goods are not produced,
Huh.
then you cannot levy the entry tax at
Huh.
all.
So that argument
Has been rejected.
had been rejected, saying that you can still impose a entry tax even if you do not produce here, but you bring it from outside. But
So-
304 says, once it is produced within the state and that goods produced within the state is also subjected to the same tax, then 304,
No,
the condition precedent of 304
No, that means,
is not applicable.
that means if a particular goods is not manufactured,
You can.
it's not manufactured in Assam.
Then you can.
Now, then there will
Then-
be no violation of 304A.
This is what it says.
No, it doesn't say so. With due respect, it doesn't say so.
No, you only refer tax only say that there
It
is
says
permissible.
it is permissible to levy.
Hmm.
Permissible levy, thereafter the further you will also see,
Which one?
further conclusions,
Which one?
1159.8.
Eight. Article founds upon the discrimination of hostile nature and not on mere differentiation. Therefore, incentive set-offs granted to specified class of dealers for a limited period of time in a non-hostile fashion with a view to developing economically backward would not violate 304A.
And therefore, OCBC 116.
Question whether levies in the present case indeed satisfied that is left to be determined by the regular benches.
1160 OCBC.
States are well within the right to design their fiscal legislation to ensure that the tax burden on goods imported from other states and goods produced within the state fall equally.
My lord.
So for the discrimination, the comparison is always goods from imported from outside the state, goods produced within the
With
state.
due respect, my lord, I will know the next date. There is no necessity of production. Now the Supreme Court has said that for levy of anti-tax, the production is not necessary. If production is not necessary and anti-tax can be levied,
Can be levied.
then on what goods? On which goods?
Goods which are imported.
So only on import the goods will be improved.
Understand?
But
So
that cannot be. That cannot be.
why?
If the goods only on import you are imposing, that will be hit by Article 304A. You must impose the similar tax. That was the argument which was rejected. That if the goods are not produced, you cannot levy the entry tax at all. The Supreme Court said that even if the goods are not imposed, you can levy the entry
You
tax.
can levy the tax.
But in case it is said
Huh.
that no, we don't impose the entry tax on the local goods, local sale from one local area, another local area, and impose only on the imported, then the upper division bench judgment
Then 304A will be violated.
violated. So production is not necessary.
But
My lord, with due respect, my lord, in case it is held,
understand. Dr. Saraf. Now, let us read 304A. Let's go back.
my lord,
Impose on goods imported from other states. This is one category.
my lord,
Any tax to which similar goods manufactured or produced in that state are subject. So if the same tax is subjected to goods produced or manufactured in this state, it is permissible to impose tax on the goods, similar goods imported from another state.
my lord.
The corollary is if not corollary, the meaning is if the goods manufactured or produced in this state are also subjected to the same tax, then you can impose that same tax on the goods imported. But if the goods manufactured or produced in the state are not subjected to the same tax, then you cannot impose the similar tax on the goods which is
I am
imported.
asking question myself. In case the goods are not produced in the state,
If it is not produced in the state, the Supreme Court makes an exception in 11597. Entry tax on entry of growth into local areas for use sale therein is permissible. You can still do it. Although similar goods are not produced. But if similar goods are produced,
no, I take it that similar goods are not produced.
no, then you can.
Then anti-tax will be levied.
That you cannot.
No, that
So to that extent, we'll clarify.
anti-tax is not leviable.
Dr. Saraf, we have no difficulty to clarify 3(1) to that extent.
That anti-tax.
But if the similar goods is manufactured and or produced also in this state, and they are also subjected to the same tax, then for the same goods imported,
Well, I'll just, for my satisfaction, I will argue next date. In case a particular goods is not manufactured or produced in the state, then I could understand that anti-tax cannot be levied. Motor car is not produced in the state. There is no motor company producing the motor cars. I think the TV manufacturing, there is no,
long time back when Empron was there.
now nothing is there.
Now it is not there.
Mobile manufacturing company in Assam, it is not there. So I prepare a list of the items which are not produced.
And in all these items you were referred just now, para 1159.7 will cover.
So if 1159 is covered, then your lordship will also.
But the difficulty is, if it is not produced, it is 11597. But if it is produced,
I'm saying they're not produced.
if it is not produced, you are,
Liable to?
Dr. Saraf, you can take our word. We'll clarify to that
No,
extent.
I'm submitting, but I'm not.
If the goods are not produced, we clarify to that extent. We'll be bound by 1157.
I'm submitting, you know.
But we are exploring a situation where it is produced,
My lord,
number one, and it is also subjected to the same tax.
My lord, I will commit.
In that case, entry tax is permissible, but if the goods are produced, but it is not subjected to this same tax, then entry tax is also barred by 304A. These are the three situations we can visualize.
I couldn't understand. If the goods are not produced,
If the goods are not produced, 1159.7 will come into play.
entry tax will be leviable.
It will be leviable. So your motor car and mobile phones are answered to that extent. If the goods are produced in the state but are not subjected to any entry tax, you cannot impose entry tax, goods imported. Third situation is goods are manufactured, but the same good is also subjected to this entry tax, manufactured in the state subjected to, then you can also impose entry tax to the goods which are imported.
That will be the case of normal discrimination.
Not discrimination, there is no
My
discrimination.
lord, I am coming.
It's a plain reading of
Otherwise,
304A.
otherwise what will happen?
And plain reading of 304A, all the interpretations given by the 9 judges bench, there, I again refer back to paragraph C732, that all these clarifications and explanation by Justice General Su's judgment is on a premises that non-discrimination as between goods that are imported from other states and goods which are manufactured within. So once a manufactured within is not subject to the tax, goods imported is subjected to the tax, Article 304A will come in and that tax has to be interfered. But the reverse situation, if the goods are manufactured or produced and they are also subjected to the same tax, then entry tax will be permissible.
With due respect to your lordship.
No, we'll hear it, Dr. Saraf, don't worry. It's
Hello?
not that we are concluding.
No,
We are
no,
just putting
There is
a,
no question, it has just started, you know. There is no question concluding,
Yeah.
it has just started.
we're just trying to understand from
It
you.
will take at least 15 days to conclude. The question is that, my lord, I fully appreciate your lordship. What I was arguing for, lordship, is that when you are not levying a tax, when the goods are resold and VAT is payable,
Dr. Saraf, 3.2 will deal with separately from the point of view of paragraph 728, which is left open to the high courts to decide.
you know, everything has been open. My points, whatever are there, I place the judgment of the next judgment.
Yeah.
When regular bench, what I said, whatever issue I will argue, that only has been left out, not dealt with by the apex court.
So anything left out will decide.
The issues which had been left out for the decision of the High Court, that only I will argue. What has been decided, that has been decided. There is no question at all. The question, only 3-4 points which are there before your lordship, is that when any levy is not there and the goods are imported and sold. And levy is there when the goods are imported and consumed.
This way, suppose we decide the question framed in para 728 in a manner that this violates Article 14 or it is discriminatory,
Madam, whether
then 3.2 will go.
whether your lordship say 304A,
No.
now
Sup-
whether 14, according to me, will not discriminatory.
Understand, in that event, suppose we arrive at that conclusion, section 3.2 will go.
No, 3.2 will not go.
Because 3.2 is the only section which is discriminatory.
Your lordship will find-
3.1 is not
Well,
discriminatory.
the 3.1 is the levy.
Understand?
The levy, I will place before lordship the judgments that when somebody is giving the benefit to someone and not giving the benefit to me, then the levy on me will be discriminatory and that will be struck down. I
No.
place,
So now, upon further propounding para 728, if we arrive at a conclusion that there could not have been a differentiation between a goods consumed and a goods resold, then the result thereof will be striking down 3.2 or striking down 3.1.
3.1, insofar as the levy on the import of the goods for consumption and use,
Then suppose we strike down 3.1.
not full. Not full. Only for the purpose of consumption and use, not for sale.
I understood your argument. We'll hear you. So you understand, we understood your argument.
Because it happened, my lord, under the Assam General Statistics, section 27 was there,
Hmm.
where all public limited company were made liable to pay the taxes.
So 3.1 as regards consumption
And use.
use will be set aside because 3.2 has provided that if it is for resale, it will not be there.
My lord.
So therefore 3.1 has to be set aside. This is the argument. Yes, we'll hear you.
Only to the extent of consumption and use.
Yes.
Because section 27 will.
So now the statute will look like High Court will strike down consumption and use from 3.1. 3.1 balance will remain. And 3.1 balance, what remains will be taken care of by 3.2 because of this discrimination. Or the discrimination has been meted out by 3.2, so strike down 3.2.
3.2.
Once I strike down 3.2, tax will be applicable to everybody.
Well, I understand. Tax will be applicable to everyone.
If I strike down consumption and use, tax will not be applicable to anyone.
Well, now the act is not there, repealed.
But
Now the act is repealed, whatever has happened for the persons who are carrying agency is go over. Now affected parties are we are consumption and use, on whose the liability is there. Now, you have given to him, I am not interested. You give to anybody, it is up to you. You give to anybody, but keep similar to me. And since similar thing has not been given to me, the imposition on me is bad. I'm not saying the imposition, the exemption granting to him is bad. No.
is that argument available in tax jurisprudence?
Yes. It is available.
No, in administrative law, definitely it's a good argument.
14 otherwise. I say that this is discriminatory. And you
Understand?
say that you told
For a situation under administrative law, it is
me. Well, the
applicable.
taxation law also, you'll also see. If I come before you also that you see, they've imposed the tax on me, similar goods have not been affected. Now, your lordship is not going to say, no, impose the tax on them. Your lordship in 226 has no power
No, we'll not say.
to take away the exemption.
No,
Your lordship has no power to take away the exemption. The state is given the exemption.
so that's why you were asking.
But you give to equal to him when your lordship makes a similar judgments that you cannot make a distinction between so and so and so and so.
We'll hear you. That is single bench is there waiting everywhere. Got something?
Something serious.
On Thursday, we'll be assembling this bench, but tentatively we fixed for 4 o'clock because of one particular matter. So do you want it on the same day?
It
Then
can be
maybe-
in the second half because
Maybe the rest of the second half. That is one possibility. Or else you choose your date.
first of all, why not? Because to-
For the other matter, we fixed on Thursday at 4 o'clock.
It কি আছে? So can it be on the Monday, like 28th, the second half?
Yes.
On 28th in the second half,
Our dates are available every day. It's difficult to get your date.
No, my date is also available.
So-
They- One or two cases here and there, they fix up and thereafter I may have, your lordship may have.
No,
case in
for
the
us,
case.
we don't even have that here and there also. We are here every day. So you take the date, Monday,
28.
Monday, do you? Okay, same order, Marisha. dear. Thank you. Actually, it meant. See, there is a concept of overruling. If an earlier judgment had been overruled or any provision thereof had been overruled, it is easy for us. We'll ignore the overruled part, but if it is not overruled, it's difficult for the High Court to now interpret whether Supreme Court had overruled or Supreme Court had not overruled. So now you are requiring the High Court to give a judgment over and above two Supreme Court judgments.
No, my lord, what has
Mhm.
been challenged before your lordship is the impugned WT message. Which has
Understand?
banned
But we are on the law. We are not on what you are challenged. Now, which paragraph you refer? Para 39,
37 lordship.
37. First, we shall examine as to whether conduct is relatable to item 17. Because what Mr. Talukdar refers, paragraph that 44 and 37, I think.
Yes, my lord.
There
Makes sense.
specifically, the Supreme Court was of the view that these bulls are not performing
Animal.
animals.
Yes, lord.
And 35. And it also gives a corresponding right to the animal to ensure its well-being. Well-being means being comfortable, healthy, happy. And forcing the bull and keeping the same in the waiting area for number of subjects constitution is not well-being. So if the animal is left alone without any human control, another animal is left alone somewhere else, that too without any human control, both are approaching each other and started a fight. That may escape the rigors of para 35. But normally it is not like that. The two buffaloes will be caught hold of, tied, forced, brought into a specific arena. And within the arena, if they don't fight, start making different kind of interventions to make them agitated so that both of them fight with each other. So human intervention comes to the extent of this animal being tied, forced, and brought to the arena. Second intervention comes when this animal is made excited so that it resorts to a fight. Suppose the two buffaloes, they start patting each other. The organizers will not be satisfied because they have to fight. Otherwise, it will be a draw. That bullfight would be a draw if suppose the two bullocks come face each other and both realize that, oh, we are old friends. So let us spend some together time here. If they are left alone at that stage, also maybe we understand something. But they're made to fight. So will this one not give this thing corresponding right to the animal to ensure its well-being and also being comfortable? And then therefore, in our view, cannot be performing animal bulls, automatically not designed for that, but are forced to perform, inflicting pain and suffering in the total violation also. So section 3 is violated.
My lord, what section 3 says?
I understand. But now
Yes.
point out to the subsequent Supreme Court judgment,
Yes, lord.
which had taken away these two rigors. You refer to para 38, 37. 37. First, we'll examine what is conducting this bovine sport. 38 is some IN Saxena, something that happened. Next comes question as to whether even after the said amendments, Dalikatu and other two activities could be held to be beyond legislative competence. So here Supreme Court possibly examined from the point of view legislative incompetence, whether the state could have enacted those statutes. The Supreme Court concluded that competence was there.
My lord, I'm reading, as we proceed on the basis that the constitution does not recognize any fundamental right for animal.
Where are you reading?
Para 37, lordship.
37.
37. Says it in-
Is it the same page I am holding? I don't know.
Lordship, mine is Manu
এই
Patra.
হেৰি কৰিব। এইখন দেখো, এইখন লিখি থাকিছে, নে বেলেগ কিবা? My 37 is only one sentence. এই হেৰি কৰক, এই একে প্ৰিণ্ট আউট ওলাই দিয়ক না, একেতে যিটো লৈ আছে। You are holding which journal?
Manu Patra.
Manu Patra paragraph always varies. This is, I think, SCC.
Yes, lord.
That's a difficulty in Manu
Para
Patra.
41, lordship. As we proceed on the basis. The constitution does not recognize any fundamental rights for animals. We shall have to test the legality of the three statutes against the provisions of 1960 Act along with the constitutional provision of Articles 48, 51 A, B and H. The three statutes will also have to meet
No,
the
Constitution does not recognize any fundamental right for animals. But here it said gives a corresponding right to the animal to ensure its well-being. So is that proposition that the animal has its own legal right to ensure its well-being has been taken away by this paragraph? That means anybody can do anything to an animal at any point of time.
Oh, my lord.
Are we to interpret in that manner?
No.
Why did the court say, let us read from before, para 41?
Previous paragraph, my lord, what the broad theme of the 1960
It has
Act
been
is that
broadly held that animals have a natural law to live a dignified life without infliction of cruelty. It is held that, but we need not refer to these authorities as we accept the obligation. So here it is. Petitioners contend that animals have inherent right in natural law to live a dignified life without infliction of cruelty. Supreme Court says, but we need not refer to these authorities as we accept the obligation of human beings to ensure that animals do not suffer. So this is recognized by the Supreme Court. Our jurisdiction, however, does not extend to provide an absolute protection to the animals from any manner of infliction of pain and suffering. What the broad theme of 1960 Act is that 60 Act means that the Cruelty Act.
this, my lord.
Cruelty
prevention
Act
of
is
cruelty.
that animals must be protected from unnecessary pain and suffering. This aspect has been dealt with in case of E. Nagaraja. This approach would be apparent from a plain reading of section itself, even before the three amendments where the legislature appears to have undertaken a balancing exercise without disturbing the What does it mean by we have already expressed our views on the point earlier in this judgment? Where is it? What views had been expressed? Nagaraja is jurisdiction. The argument that amendment acts are void because they seek to override A Nagaraja cannot be sustained. What is there in A Nagaraja?
A Nagaraja was there, 2014 judgment.
Understand, where is it discussed here? In which paragraph, Nagaraja? What kind of changes were brought in by those three amendments?
Lordship will find in the new judgment.
No. If you read paragraph 39 of the copy I am holding. No, paragraph 32. 32 said the factual conditions prevailed at the time when A Nagaraja judgment was delivered cannot be equated with the present situation. We cannot come to the conclusion that in the changed circumstance, absolutely no pain or suffering would be inflicted on the bulls while holding the sports. But we are satisfied that large part of the pain inflicting practices as they prevailed in the manner these three sports were performed in the pre-amendment period have been substantially diluted by the introduction of the amendments. So where are the amendments?
Amendments, Lordship will find the new judgment.
Yes.
A copy I am holding is in space, a paragraph.
You are
12.
holding
12.
Monopatra or Bonopatra?
Even the,
Which paragraph?
it is in paragraph 12.
12.
There is a chart, my lord, what are the,
One, that all those
yes.
long ones.
Yes,
So after the
Yeah.
chart,
Of the chart itself, my lord.
chart, which,
Firstly, the scope,
just a minute.
scope,
Why is it published like this? Okay, in ATI,
what are the amendments made in the state act?
okay. So which one you are reading? Scope.
Firstly, the scope.
Huh.
An
Act
act
to
to amend the Prevention
prevent-
Cruelty to Animal Act 1960 so as to preserve the cultural heritage of the state of Tamil Nadu and to ensure survival and well-being of the native breed of bulls. Then Lordship may come. Section 3,
An act to amend the prevention of cruelty, other one, an act to
also to preserve the culture.
Preserve the
prevent
culture.
infliction of, and also to preserve
Preserve the
culture.
Yes,
So,
so this was the.
no,
amendment.
this is we understand. But why did the Supreme Court say that we are satisfied that large part of the pain inflicting in these three
Part
sports
has
were
been-
performed in a, had been diluted?
Done away with.
No,
In
diluted.
fact,
diluted by the introduction of this. What dilution was made?
Paragraph 30.
Some kind of restriction?
Yes, restriction by
Restrictions in the nature of plane to be inflicted.
pain to be.
Where is it?
Lordship, I'll come. In our opinion, the expression Jallikattu, Kambala and Bull Cart race as introduced by Amendment Act of three states have undergone substantial change in the manner they were used to be practiced.
Where are we reading?
Paragraph
Paragraph 30.
30, but
Of Manupatra.
possibly
Does it begin with in our opinion?
Yes, Lordship.
in our opinion,
I read that para only just now.
practice perform in factual conditions that prevail over.
That's what we are asking. Supreme Court said the new acts have substantially diluted.
Change in the manner they were used to be practiced.
So we want to read the act. What change was brought in?
But we are satisfied that the large part of pain inflicting practices as they prevailed in the manner in this to where.
That is precisely what we're asking.
Right.
What change had been brought in the Amendment Act which had diluted the pain?
Lordship may take up that chart again.
Then
Section 3, my lord,
three.
3, the duties of the
Hmm.
Section 3 lays down the duties of the person having.
Duties of
charge.
the persons having.
Then Section 3 has been amended as principal act shall be renumbered as well so. And after as they renumbered, the following subsections shall be added, namely, notwithstanding anything contained in subsection 1, the conduct of Jallikattu subject to rules and regulations, as may be filled by
The conduct is subject to rules and regulations.
shall be permitted. Now, under these rules and regulations, some restrictions are imposed.
What are the restrictions? That's what I'm trying to understand.
It is.
Can we allow this fight also subjected to a similar restriction? That is what we are trying to explore
Similar restriction has to be done by the state only,
in this case.
because it
No,
has.
no, as the state has not done, can we judicially do it? There is no prevention.
I do not know,
No,
but this.
so till such act is done, it can be provided. So we are trying to understand what kind of dilution in infliction of pain had been accepted by the Supreme Court. And whether similar diluted pain infliction can be accepted in the present case.
Lordship may in that case kindly come to.
Say earlier, there was a system of taking out the horns.
Yes, Lord.
Now that is prevented. That is a dilution in the infliction of pain. Earlier it was no holds barred, they can do anything. Now certain things they cannot do. Is there any such provision in the amendment?
Amendment, I do not know because I have not seen the rules and all. It doesn't speak of
I
that.
think we need to
But,
get into that aspect.
Then section 22 was, my lord, amended, 28A.
Try to find out.
And lordship may come to paragraph 31, the paragraph which your lordship was reading, my lord.
31 will be my 33, I think.
In our opinion.
We have read that.
Then next paragraph.
Can the amendment?
Yes, can the amendment, last few lines, my lord. For instance, while other means of carriage of goods are available, why should bulls be permitted to undertake such activities?
Where are you reading?
Paragraph 31.
31.
No, your para and my para is not matching. So you have to tell me the beginning
Can
word of
the
the paragraph.
Can that amendment?
We are reading that one. Can the amendment be struck down now?
For being arbitrary.
Ah.
There is a body of case.
Now here, which sentence you are reading? Horse is also a sentimental animal, that one.
After that.
But
after
the fact
down
remains.
below, but the fact remains that by making them perform in the races, some element of pain and suffering must be caused to the horses. Here, the focus shifts from causing pain and suffering to the degree of pain and suffering to which the benefit of human being. Similarly, proponents of the vegetarianism may argue that
Not relevant for
slaughtering, no, it is relevant because lordship, it is not necessary as human being can survive without animal protein. In our opinion, we should not take up the balancing exercise,
No, that's
which
what-
has. Well,
No, we are not taking any balancing exercise. What we are looking at that
whether we.
the
what can guarantee.
earlier Cruelty Act had absolutely prevented any kind of pain being inflicted. By the amendment brought in by the Tamil Nadu, Karnataka and Kerala, I think, or Andhra, certain manner of inflicting pain was possibly, it was accepted. Supreme Court had expressed the view that this dilution in the infliction of pain
Has been done already.
no. We are satisfied that large part of the pain infliction had been done away with.
Done.
So
So.
if to that extent the pain infliction is done away with, Supreme Court is satisfied.
Right.
So in the present case also, in case of this buffalo fights,
Hmm.
if infliction of pain of that nature is not allowed,
Yes, my lord.
But to a lesser amount of infliction.
what is
whether-
allowed in that turn, and Supreme Court says we are satisfied.
Yes.
Why can't we also look it from that point of view?
That can be the, but further down below it says.
So you are questioning whether under 226 we can do that. We'll find a way out.
No.
That's not the issue.
Otherwise,
Issue is first, let us see what can be done, what cannot be done.
It says that this kind of exercise ought to be left for the legislature to decide upon. And another paragraph also. In which is for- 24, my paragraph was 24.
Beginning,
On the question of conferring fundamental rights to animal.
on the point of,
On the question of.
Question of conferring fundamental rights
Lordship,
to animals.
after that.
26, I think.
Yes. Yes, Lord.
We
On
do
the
not
question
have
of
any
fundamental-
precedent. The division bench in case of A. Nagaraja also does not lay down that the animal have fundamental rights. The only tool available for testing this proposition is interpreting the three amendment acts on the anvil of reasonableness in Article 14 of the Constitution of India, while the protection under Article 21 has been conferred on a person as opposed to citizen, which is the case in.
we
Article
have a
19.
doubt whether detaining a
We-
stray bull from the street against its wish could give rise to constitutional writ of habeas corpus.
Now it says, Mother, give rise to constitution so and so, and Nagaraja. The question of elevation of statutory rights to animal to the realm of fundamental rights has been left to the advisory level or has been framed as judicial suggestion. We do not want to venture.
Okay, Mr. You find out that. Yes. I think let us attend to some human problems also. Almost 45 minutes we devoted to animal problem. Let's give some time to the human problem. Both MS B. Chaudhary as well as Mr. Vijay Talukdar, that's in the council for the respondent, B. Chaudhary for the petitioner, have taken the court through the provisions of paragraphs 35 and 44 of the judgment of the Supreme Court rendered in Animal Welfare Board of India versus A. Nagaraja. That A. Nagaraja, this is the judgment, referred as Nagaraja judgment.
Yes,
Okay. Reported in 2014, 7 SCC, page 547, as well as the judgment rendered by the Supreme Court in Animal Welfare Board of India versus Union of India and others, reported in 2023 SCC online SC 661. Wherein in paragraph 26, not wherein in paragraph 32, the Supreme Court expressed its satisfaction that by the 3 amendment acts to the Prevention of Cruelty to Animals Act, a large part of pain inflicting practices as it prevailed prior to the amendment had been substantially diluted by the introduction of the amendments. The relevant amendments referred by the Supreme Court, which had diluted the pain inflicting practices, may be indicated. Let's not. Take a fixed date because we'll have to balance with all the learned council. Because all matters will be listed on the same date.
Right.
All the single bench matters. Every day we can't have this bench. A date to khali rakhibo. Ultimately, you agree to one date. I thought there may be some answer to that. No possibility.
I think.
Ms. Palu, the date will give a little later because other matters are also there. So it has to be a convenient date for everybody. Question paper,
Yes, ma'am. Double taking.
double ticking. Where is Mr. Nath?
I saw Mr. Mazumdar after little while back.
Mr. D. Mazumdar is in code number 1, my lord. He's in legs.
They will come on next.
Next day.
No, report is there, madam. No problem.
Adjourn on the inconvenience of Mr. D. Mojuna, learned additional advocate general. So we'll list it again on a date to 31 at a common date.
Much.
May please announce. Last occasion, Rasif call for the record.
কেইদিনমান আগতে এখন notification ওলাইছিল নহয় গুৱাহাটী হাইকোৰ্টে যে পাছ except for some category of cases DB1 এইটো চোৱাচোন কভাৰ কৰে নেকি কৰিলে it has to go to DB1 এই কেইদিনমান আগতে ওলাইছে এখন কাবাৰ ৰেজিষ্ট্ৰি কৰিছে তেওঁলোকে জানিব You have the record with you?
Yes, lordship.
Hmm?
It has been next year.
Why did you call for the records? What is the question?
My lord, is it interest seniority my lord, of the LDA? Office of the District Judge, Kamrup Metro.
2/3/2023. The respondents needed to make the record. The appointment letters of respondent was 6, 7, 8, and 9. And the orders of transfer in respector is by 8 and 9. That's only the appointment. So you're claiming seniority,
My lord,
LDA,
yes.
in the office of the district
Judge.
judge Nagaon,
No, my lord. Kamrup Metro.
Kamrup Metro. Okay, Kamrup Metro. So petitioner was placed below in the seniority.
My lord.
And 6, 7, 8, and 9 are placed above the petitioner.
My lord.
Why, Mr. Sharma? What is the reasoning?
Lordship, in terms of the final select list, lordship, in terms of merit, lordship, the seniority was to be assigned, lordship. And
At the time of recruitment, whatever was the order of merit, that will determine the seniority.
Lordship.
So all these people recruited in the same selection process,
Yes, Lordship.
same selection process.
Advertisement was of 11/4/2013
Hmm.
and Lordship subsequently written examination was held on 36/2013.
Yes, let it be. Ultimately, one merit list was there,
Yes, yes, Lord.
and in the order of merit, the respondents are higher than the petitioner.
Yes.
So you
That
place the
was-
petitioner above, respondents above.
Yes,
This is your case.
yes. Lord.
And on what ground you
But,
challenge?
Rule is not that, my lord.
Hmm?
Rule is not that.
Where is the rule?
Rule, my lord, page 52 annex F. Rule 12, lordship.
Page number, sorry. Except service matter. Rule 12.
Rule 12, lordship.
Where do we get the rule 12?
52, my lord. Page number 52. The rule is called as Assam
In
District.
the
and-
lower, seniority will be according to the date of appointment. If you join the appointments within 15 days.
Yes,
Date of appointment, if within 15 days of the receipt of it. So what is the date of appointment?
the petitioners are appointed, my lord.
Date of appointment, Lordship, the final select list may be.
No, no. That is later on. What is the date of appointment?
Lordship, the dates are different, Lordship. And while.
See, it is your rule.
Lordship,
In LDA, seniority shall be according to date of appointment. Okay.
Lordship.
If the person joined appointments within 15 days, the petitioner joined within 15 days. Now see, when however more than one person are appointed on the same date, their interstate seniority shall be determined according to their position in the merit list.
Only those.
So that
persons-
is the second consideration. First consideration is date of appointment. So for any reason, unless the date of appointment is challenged by someone, if you have given appointment to the petitioner at an early date, petitioner will be senior, going by the rules. How can you go to the second criteria and go by the order of merit if the first criteria is satisfied?
Lordship.
Only when first criteria is equal, then the second criteria is to be followed.
Yes, Lordship, but in this case, what had happened, Lordship, due to some infrastructure problems, Lordship.
Whatever it is,
Lordship, that was
but
mentioned,
does the rules provide for such mitigating circumstance?
Lordship,
It
that
does
was
not.
in the final select list, that was what was mentioned, Lordship.
How, where do you get the authority to do so?
Lordship, since the posting of. some
No,
of
no,
the
understand.
candidates-
Where do you get the authority to do so? You could have given the date, issued the appointment order, then also passed an order. Your date of joining will be deferred. Then it is okay. Because the infrastructure is yet to come to place. So we defer your date of joining.
Lordship, that was what was there in the final select list, Lordship.
Where is what is there in the financial? list?
Lordship, that might be in the records, Lordship.
Find out,
Flat G, Lordship.
take it out. Hmm. But once the statutory rules provide for, so how can you come out of the rules? Your convenience or other factor cannot be a reason to ignore the rules and devise your own procedure. have you made the others respondents?
Yes, the private
Uh,
respondent,
Somebody is appearing.
to 6 and 7 are okay.
No, what about all? 8 and 9?
8 and 9 not okay.
They are not made a respondent.
They made this.
Is somebody appearing for them?
No,
Notice served.
notice sir.
Are you sure? Just check
Yes,
out the
notice,
record.
notice sir. Dusty service also there and
That's
registered.
why
date.
judicially it has been accepted that notice served.
Notice sir.
Mr. Sharma, is there any legal proposition available? That because of inconvenience, etc., all kind of justifiable reason,
In the second part of.
in justifiable reason, if the date of appointment is later of a particular candidate, authority retains the power to restore back the seniority. Do you have any provision giving you such a power?
The merit list was published.
Mr. Sharma, please don't give a different reply.
No.
We know merit list was published. Do you have any such provision in the rules to remove difficulties, something maybe that any such provision is there? Sometimes the rules themselves contain a provision that in case of extreme difficulty, you can either relax or this thing. Do you have any such provision?
16 rule 6.
16,
The next page 53.
understand. Anyway, operationally may cause hardship when it may experience a relaxed but equivalent to such extent. Very well. Did you exercise this power and pass any order?
That instruction I'll have to.
Not instruction, the records will contain.
That's.
I think that's your only way out. If you had relaxed Rule 12, considering the undue hardship, then we don't know, we look at it from a different point of view. Otherwise, you are bound by it.
Lordship. Lordship may kindly peruse the rules once more, Lordship. Rule 12, Lordship. There is
You-
Lordship,
You still feel that we have not understood the rules.
Lordship,
Then why do you want to read the rule once again?
Lordship, it's been provided, Lordship, that the appointing authority has got. May,
Provided further interest on the same date shall be according to following order.
provided that in case the person prevented from joining within the said period of 15 days by circumstance of a public nature or for reasons beyond his control, the appointing authority may extend it for a further period of 15
Huh.
days.
Did you extend?
Yes,
See, Mr. Sharma, this provision means you will issue the appointment order with a requirement to join within 15 days. If there is difficulty, you may extend the 15 days. That does not mean you will not issue the appointment order. Here is a case, appointment order was not issued at all. So that is not applicable. Mr. Sharma, I don't think you need so much of time for this. matter.
postings were being modified. Lordship.
Doesn't matter. When do you gain the power? Every administrative act must be backed by the authority of law. Otherwise, anybody will do anything they feel like.
I shall obtain that instructions.
Only saving
Rule 16.
occasion for is Rule 16, if you have relaxed the rules.
Question of election of the rule also not there. It is not at all applicable, my lord. Lordship will find the appointment letter, my lord.
Madam, don't make those atrocious submission that a relaxation rule is not applicable. It
this-
can be.
He is placing the case otherwise, my lord. This is not the case, what he is placing, my lord.
Then what is that?
My lord, Lordship will go to the appointment letter, page, my lord, 27. Page 27.
Yes, what is it?
My lord, here 15 persons were appointed.
Sorry?
Page 27 appointment letter, my lord.
Huh?
15 persons were appointed.
Appointed.
Their names were not there. They were not appointed with along us, my lord, so that their seniority will be determined.
And Borman, have you understood what he is saying?
He said-
He is never saying you are appointed on the same day. He is admitting that they are appointed later on.
Later on, my lord, yes.
When they are appointed later on, definitely their name will not be in page 27. But what he says that due to lack of infrastructural facility, although these people are higher in the merit, they could not be issued the appointment order. Because either the room was not there, or the table was not there, or the chair was not there. Once the structure came into place, they were given the appointment order.
Right.
So therefore they say that as because it was on the lashes on their part or lacuna on their part, why it could not be issued earlier? So we have restored the seniority. This is his case. So your argument does not hold good. To overcome it, only relevant provision is whether they have relaxed the rules. That's all we want to see. Find out whether you have relaxed the rules or not.
Sometime maybe granted.
I heard MSP Borman may be also. The writ petitioner was appointed as a LDA in the establishment of the District and Session Judge Kamrup Metro by an order dated 4/3/2014. Whereas the respondents number 6, 7, 8, and 9 were appointed.
Six
Yeah.
appointed on 28/7/14,
6 was appointed on 27,
28/7/2014.
28/7/2014,
7 was appointed on 23/6/2014.
7 on 26,
23/6.
23/6/2014.
8 appointed 22/7/2014.
लिख लो वहाँ, 8, 11, and 9.
9/4/8/2014.
The petitioner accordingly relies upon Rule 12 of the what rules? Of the Assam District and Session Judges Establishment bracket Ministerial Service Rules 1987, which inter alia provides that the seniority shall be according to the date of appointment, where it is further provided that if more than one person are appointed on the same date, their inter se seniority shall be determined according to their position in the merit list. Full stop. Mr. MP Sharma, Land Council, appearing for the District and Session Judge Kamrup Metro, raises a contention that when the petitioner and the respondents were required to have been appointed, there were certain lack of infrastructural facilities, which resulted in a delay in the issuance of the appointment orders in respect of the respondents number 6, 7, 8, and 9. To mitigate the circumstance, the respondents accordingly restored the seniority of the respondents number 6, 7, 8, and 9. Full stop. A question for determination would be, if the rules are specific that the seniority will be determined on the basis of date of appointment, whether any other mitigating circumstance can be taken into consideration to reverse the order of seniority by ignoring the requirement of the rules that the seniority will be on the basis of the date of appointment. No such provision could be pointed out other than Rule 16 of the rules, which provides that in the event of any undue hardship being caused in any particular case, the appointing authority, if satisfied, the operation of any of the rules can be dispensed or relaxed according. Sorry. In the circumstance, we require the respondents to produce any relevant material from the records that a conscious decision was taken under Rule 16 to either dispense or relax the requirement of Rule 12. The records, if any, may be produced on the next returnable date, list on so and so.
Lordship will also.
The records given is returned back to be produced again on the next date.
The Lordship, the
Next
requirement.
item.
Much okay.
The last update, there were two directions. One for the personal appearance of both the inspector of schools who had held the post then, and for me to confiscate the records regarding the suspension of the.
Who is the person with you?
The additional.
Additional secretary to the government of
The additional secretary to the government of Assam.
Assam, now holding the charge of chief executive
Then
officer.
why are you with the petitioner?
There is a direction, my lordship. He is the.
Is there a direction to be there along with the petitioner?
Yes,
Why?
he is the petitioner, my lordship.
He himself is the petitioner.
Yes,
I
ma'am.
say that. So why are you giving some designation and all?
There was an IA filed by the private respondent. Perhaps it has not come on record, I do not know, it was filed day before yesterday, my lord. Although he was required to be present personally, his wife is undergoing treatment at Madras
Who?
for cancer, the private respondent, my lord.
You have filed one IA.
My lord, yes, and I.
So you want a deferment
And
of the date of appearance.
Exemption for
Yes.
today and a deferment. by-
When?
My lord, he says
What
that
is the matter about?
there was a suspension order.
When somebody is speaking, it's a worst of the habit to also bring. Let him complete.
A particular teacher of a particular school was suspended and he approached this honorable court saying that I have been suspended because I had moved a transfer, an application for transfer. This honorable court took up the matter in while sitting in the matter, and orders were passed that the person who had suspended him did not give any reasons for suspending him. No records were available, and therefore,
The suspension is not valid.
and a cost was imposed upon the officer who had given the suspension order, who is present in the court today.
So now this is a review petition
Saying
against the
that they
imposition of cost.
And saying that there were records available with the department, which the respondent, who is now might not before the honorable
He
court,
is withholding the records.
that he did not produce the correct records. Therefore, lordship had directed in the review petition that both the persons will be present and
Definitely.
records will be confiscated. Records confiscated. my lord. I have the records as available with the department.
So records are available. So the writ order, then it will be incorrect.
No, the records were only called for to see whether there was
No.
any reason for the suspension or
No,
not.
no. Cost was imposed. Why was it imposed?
Because
When is the order imposing cost?
my lordship. As the
What is
review petition,
the reason for imposing cost? Because records
70.
not available or because of wrongdoing?
lordship will find it page 78.
In view of the aforesaid conclusion, respondents is directed to pay the complete salary. Because the manner in which the petitioner was placed under suspension, the reason thereby revealed from the records and from the act of the authority who had suspended in such arbitrary, unreasonable, high-handed manner. What is the arbitrariness? That he had made an application for? He had made an application for
and
transfer, so you suspend him.
on the same day he was suspended.
Give him the records, let him find out. Yes. Find out the records. Why you were transferred?
IA for exemption is here.
Sorry, that will take up. That will do.
On the record that, record open.
See, ordinarily, if a man makes an application for transfer, he may have 100 reasons to do so. You have every right to reject it.
Correct.
But you cannot suspend him. That will be definitely arbitrary. That why did you make an application for, so you are suspended? Why do you suspend?
Is in continuation of a department.
Departmental proceeding.
Or
Departmental
PSS
proceeding
section.
is on the premises of a existence of a misconduct.
Yes.
He is making an application for transfer a misconduct. Do we have to understand under the law? Is it a misconduct?
My lord.
That may be a case for rejection.
Yeah.
That is a absolutely different circumstance. Is it a misconduct? So find out from the record why you were suspended. If you have suspended without reason, now the cost will be doubled up.
My lord, sir.
Don't do any dramatics here. Behave yourself.
So many allegations are there against him, sir. And
Mr.
I conducted the inquiry against him. After conducting inquiry, he was found that he is a he was,
So,
yes, sir.
so where is the order of suspension? Let us see.
The review petition is it is at page 37.
Page 37. Who appears for that writ petitioner now?
Notices of
Notice yet to be issued. Pending drawal of departmental proceeding, Mojibur Rahman is placed under during his suspension, so and so. So, in the writ court relied upon an inquiry conducted by the block elementary education officer. So he is the writ petitioner, Mojibur Rahman Bormiya.
Yes.
He's a writ petitioner, I think.
My lord, the school where he was working.
Please. You're not supposed to. We'll hear you. If you disturb, neither I can hear you nor we can understand anything. Let us go logically, step by step. We will give you all the hearing that is required. You are he is the earlier DEO,
Yes, in charge DU.
earlier. Okay. Now, who conducted this inquiry? Block elementary education officer. The inquiry relied upon by Mr. Mojumdar.
My lord,
Block elementary education, the
Please.
BU.
Time may come, we may request you to please go outside. And when your turn comes to address the court, we'll call you again. Why do you disturb all the time? You're getting a fun out of it. Or you're trying to improve your case. That don't allow the court to understand anything. Let me superimpose myself on everything. Next step will be, you'll be placed outside. Till we are ready to hear you. Who is the block elementary education who had conducted the inquiry?
my lord, once he made an application against the suspension for calling for the.
We are asking a specific question. We relied upon an inquiry report by the block elementary education Hailakandi dated 1/2/2022.
Yes,
Who is this block elementary education officer?
the name, my lord, the name I'll have to find out. Name I'll have to find out.
We want his presence in the court.
On the next day, I'll have the block elementary education officer, then. block
Because
elementary-
he says that during inquiry, Mojibur Rahman states that he was performing his duties regularly and due to illness, he submitted an application to transfer him,
Yes,
but was suspended. So this block elementary education did not bother to make a complete inquiry and submitted a
on the next paragraph, lordship.
during it attempted to trace out find original records
of the
which a
case.
teacher placed them, but it could not.
It told them.
But if the records are now available,
No, the records still do not have any history of why he was suspended. There is
but
a,
he is pointing out, he is saying that there are,
from the records, if you can show me, there's no problem. I have given him the file. Let him show anything.
but you have to produce it from the records, not from your pocket.
That envelope I have.
From the, and don't tamper record. If you tamper with record, you'll be in more serious problem.
Yes.
Don't put one paper which is not there earlier. Don't do all those tricks.
Just for assistance, my lord, we put the file number at top of the every order contains the file number at the top of the letter. It's the issue number.
Huh.
The file number is there
Huh.
in this file.
Huh.
So he has to trace it out from this.
So-
file. It's available.
During inquiry, it has been attempted to trace out the original record as well, but it could not find out. So block elementary education officer did not find out the original record.
The original record regarding the.
So now
suspension-
how, from where did it appear now?
Regarding the suspension, there was only a suspension letter, no other records were there. That is what was stated.
So now what are these records?
These are records after the suspension. It starts with the suspension order, thereafter it follows.
Let us see those documents you were selling, several allegations. What is the date of that document? See, Mr. Officer, you were walking a tightrope. You were walking a tightrope. If everything goes well, the order will be in your favor. If something goes wrong, you'll be in bigger trouble. Yes, let us see. See, let us see the date of the document he is referring.
Yes.
That there are materials against Mujibur Bhaiya. What is the date of those materials? Let us find out. You go, Mr. Officer,
Here,
go to Mr. Mojumdar and find out.
here there is nothing. prior
Not
to
here,
the-
he showed something. What did you show?
My records.
Where are your records, Mr. Mojumdar? There?
This,
No, the one that you produced today.
yes,
It is
this
there.
one. I had taken it.
So
back
now
from
what he is producing?
them. Just some documents, some newspaper cuttings.
Let us see. Yes. Hand over all the documents, we'll go through it.
One, the inquiry report submitted. These are the various papers that related to particular officer who is involved in the politics. These are the,
You are still working.
no, sir.
What happened to you, your service?
Now I am actually working as additional secretary to government of Assam.
Still working under the government.
Yes, in another department, sir.
Wherever it is, you are working.
There is a court order.
Just a minute. The order of suspension is 9/1/2019. After receiving this one, what did you do? Yes. After receiving this complaint,
Sir,
what did you do?
I put one officer below me who was working.
Where is that record?
Yes,
Okay.
I have given, sir.
Where?
There, sir. On Baharul Islam.
Please put your finger down. Maintain some decorum in the court.
Sorry, sir.
Don't be sorry also. Be sorry to yourself. You're supposed to be a man in the additional secretary now. And this is your behavior. Yes, what kind of people you are employing? Doesn't even know the basic manner. Anyway, yes, Find out where is it.
Page 23, read petition.
What you did after that, please point out. Give one by one document, not all at a time. After receiving that complaint on the 2018, what did you do next step? এখন দিদিবা এখন তোমাক কৈ দিয়া এখন ৰাখি থোৱা পিছত কি কৰিলে এখন দিয়া
I deputed one officer.
give it show the records what you have done.
What about the suspension order issue? The document is not available.
Firstly, you had taken note of a complaint made by some political element. This is one aspect. And so what did you do? Please show. Where is your inquiry? Let us see.
This is the important.
This is the inquiry.
Let us see. Not report. What did you do?
I deputed my.
Where is the order deputing someone?
Sir?
Where is your order deputing the other person to make an inquiry? Inquiry cannot be done without any order.
Sir, actually, that may have been in the office file, but after my.
Get your office file.
Sir?
Why did you come to the court without your office file to defend yourself? Get the file.
Sir, I am not now in that office, sir. I am the one.
Get it.
Another district, sir.
Get it. Go and get the file. Or we apply under the RTI. So now, who is PT Loskor? You are Loskor.
Yes, sir.
Ah. So now, after getting a complaint from a political entity that I am a primary member of the Indian National Congress and sought party ticket, from that man says, Mojibur Rahman is also a political element. He is not doing his duties well. On that basis, you submitted a report before the.
Not myself, sir. This officer was working under me at attached officer.
Why did he submit this report?
He was asked to,
Who asked him?
I asked him.
Where is that order asking him?
Actually, sir, I actually.
Go and get everything. Don't come to the court otherwise.
The file was there, sir.
Your another cost of,
I was transferred from that.
you pay a
office.
cost of 5,000 for wasting the time today.
Sir,
If you want to matter to be heard.
I was transferred from.
See, this is a public court. We have no time for these personal disputes here and there. Our time should not be consumed. Lot of people are waiting for their turn.
After my transfer, all these things they have to be done, sir.
We'll hear you everything, but with supported by records.
Yeah.
Your name?
FR Loskor, sir.
Mr. F.R.U. Loskor is present before the court and takes a stand that the writ petitioner was placed under suspension in as much as there was a complaint dated 21/11/2018 by one Hafizur Rahman Loskor, Chairman, Barak Development Parishad, who introduced himself to be a primary member of the Indian National Congress and had sought for some party ticket to contest the post of president of North Narayanpur Gaon Panchayat. The complainant also stated that the writ petitioner Mojibur Rahman Bhuiya, who is a government teacher, is also a well-known spokesperson of the Hailakandi District Congress Committee. But he is more busy with his political activities and not perform his duties as a teacher well. And therefore, the political entity required the District Elementary Education Officer Hailakandi to make an inquiry and take suitable action. Based upon the said complaint dated 21/11/2018, it is the claim of the review petitioner, namely so-and-so, that she had ordered an inquiry to be conducted, and accordingly, BT Loskor, attached officer to the District Elementary Education Officer, had submitted a report that Mojibur Rahman Bhuiya report that the local public had reported that Mojibur Rahman Borbhuiya attends school half a day, and and there is no other teacher in the school, and he himself maintains the assistant register. If there is only one teacher, what will you do? He should have gone to you to maintain the register or what? And due to negligence in his duties, the education environment in the school is totally collapsed. The attached officer to the DEO Hailakandi also stated that it is a fact that Mojibur Rahman Borbhuiya is irregular in his duties. The petitioner claims that it is on the basis of the aforesaid two materials, the writ petition of Mojibur Rahman was placed under suspension, and not because, as stated in the inquiry report relied upon by the court in its judgment dated 1/6/2022 in WBC 2279/2022, that the suspension was effected because Mojibur Rahman Borbhuiya had made an application for it, requesting a transfer. Who is personally present to produce the complete records of ordering the inquiry, and under what circumstance the inquiry was ordered, and why the review petitioner deemed it appropriate to cause an inquiry on the basis of a complaint made by some political entity. This one, let's say to the fixed it.
Exemption for today.
Sorry.
The application for exemption.
For the reasons stated in the litigation, the personal presence of the applicant is dispensed for today, but to remain present on the next returnable date.
Yes.
My lord,
Or hard for the DD about it, final order over the.
my personal appearance,
If he wants, he can come. If he doesn't want, he is up to him.
I will dispense with, I'll represent my lord.
If he is remaining present, he is unable to explain anything. What will you explain by representing him? Let him remain present. He himself is unable to say anything about his own case.
I humbly request you to please pardon me. So actually, after my transfer, file was not with me.
Mr. Mojumdar, help him in getting the file.
Yeah,
Give him whatever file, if he approach, whatever file, give a exact photocopy of that file, whichever document you want. Don't hand over the original file to him. Make photocopy of the relevant document he wants. And you'll do it in the presence of the present DO. For the purpose of producing the records, the review petitioner is allowed to inspect the records in the office of the DO Hailakandi. And whatever document is sought to be relied from the records, a photocopy thereof be provided to the review petitioner. But the examination to be done in the presence of the district. Yes. No, I have fixed it with you.
My lord, my personal appearance may kindly be dispensed.
Sorry, no. We want to hear you. So this is the reason why you place the man under suspension. If it is so, why there is nothing in the note sheet? Why everything is only in the mind?
Sir, actually,
This man must be preventing your man who wants a ticket to contest, must be causing some obstruction, so this man must be removed from the road.
just after that, before my trial of proceeding against him, I was transferred, sir. So after my transfer, they may have been actually.
They have rightly transferred you. They don't need a person like this who is interfering with the political element.
I was transferred as actually, I was holding the additional charge, sir. It was the additional charge.
I already indicated you are walking at tightrope in this proceeding, having filed it. We are going to go into the complete details, look into every record. If the records are otherwise, some further action also may be suggested. So it was safer for you to pay that cost and be free, rather than going for a review against the imposition of cost. We require your presence, thinking that there will be some good materials you'll produce. Come back with the complete records. Because otherwise, your today's presence is incomplete, as you were not there with the records. You bring in the complete records, get yourself cleared. We will not only withdraw the cost imposed, the cost may be imposed on the block elementary education, the person who had given the wrong material. Don't worry, you'll be protected. But you'll have to prove your case first. As you are in a review to withdraw the cost, we'll allow it. And if that is wrong, action should be taken against the other person. It will also be taken. And you will be cleared. But you have to bring materials to show that you are clear.
This particular teacher was earlier also, sir, actually convicted.
You were addressing press conference or the court? Again, we are putting this question. So where do you collect these kind of officers in your department? You are Fazul Haq Law School.
No, sir.
No, not that.
That is correct.
What happened it ultimately?
Actually, he was.
No, what happened? This is only somebody issues a notice. What happened?
It was a case of 2000.
Understand what happened to that case? Somebody lodged a complaint against this headmaster, but what happened ultimately? Nothing. So if somebody issues notice, you will suspend him. Then you rely on some newspaper excerpts, photocopies. Tomorrow, if the respondent publishes a news item that, what's your name? Huh? F.R.U. Loskar had committed murder. Can we convict you? Mr. Majumdar will produce a newspaper report. Or court is required to do something more.
Sir, I sincerely tried to improve the condition, educated condition of Hailakandi by putting one.
Again, you are holding the papers.
And I was awarded. Awarded.
You are addressing press conference or a court of law, Mr. Officer. Behave yourself. You are under a strict warning, mind you. Next thing, we may drop a contempt against you for your behavior. Yes, what is that? What innovation did you bring? What kind of innovation you brought into the education system to get this recognition?
In the system. of
What are your contributions to the education system in Assam, so which resulted in getting a national award?
The innovation of midday meal, providing midday meal.
Where, what innovation you brought? Give us two innovations that you have brought in. Examples of two innovations that you have brought in, which resulted in a national award.
As regards the cleanliness and kitchen garden,
Hmm.
regarding,
Sorry,
as regards the cleanliness in the schools,
Cleanliness.
providing regular.
so that is an innovation. You brought in cleanliness. Cleanliness whom? Students or school or where?
Cleanliness in all respects. Sir.
Huh?
Cleanliness in all respects.
In all respect.
Yes, sir.
Show us one activity regarding cleanliness.
Including kitchen gardens, sir.
Understand? Give us one instance where you had done that. Say on so and so day, I took so and so people with me and they indulged in some cleaning activity somewhere. Give us one instance. Who is given this award? Just kind of authenticity of this one. What is this institute? We keep it with you on the next day, tell us. Make it kind of. Who are they? Mhm.
Deemed to be university.
Yeah, we read that.
Huh? Government. National Institute.
Gogo, have you seen that one earlier? See, one of your respected officer had got a national award. So department is not even aware of it. Why? It should have come in the newspaper if one of our officers here got a national award.
Since it is from a university, he must have applied.
National award after all.
He must have applied or some.
I don't know what he did. Find out. National awards are supposed to be a national news, I think. Any kind of national award. Whether it is movies or sports or education or anything else.
I'll try to find out.
Please remain present on next date, Mr. Officer, and come with the entire records. We passed our order that you can inspect any record you want. Photocopy of any document in one, they'll give it to you and come with it. Rest of the matters, next day we'll hear, and the next day try to make it a more complete day for the French. No? After two division benches, it's almost. As good as one. Yes. Sorry, you said something?
No, he asking whether they should give, I mean, it's okay, they should keep it.
Hmm?
The certificate, they should keep it, I told you.
I don't understand what you said.
You were asking whether I should retain the certificate or
I told
return
you,
it.
Definitely, we want to know, and we want to know
retaining
why the department is not recognizing a man who got a national award. Maybe this is a good ground to withdraw the cost also.
Yes.
We've done something. In that.
তোমার ডেট তো কেমন একদম ঘর পৌঁছে যাবো কেউ চিন্তা করেছে এমন একটা ইয়ন দেশে হোক তার ফাইলের মধ্যে আর কিছু লেখা নেই ফাইলের মধ্যে বলছেন যে ধর ফাইল এটা এই মাস শোনা তো যায় না ফাইল মিসিং তো দিন মিসিং এটা না তো যায় না তারা তো লেখা ফাইল না রিজনটা কি তেটু সালা নেকি কেটে লাগে আইটেম 6 অফ ইন্টারভিউ কিছু না Yeah. What is last count ya con que aquí de la